Thank you. Good morning. Good morning.
I got the whole thing signed.
We are on day 6 in the hearing relating to surface water quality permitting with state programs, docketed by the administrator as WQCC 2574. We're going to begin this morning with the Water Protection Organization's final witness, as I understand it. We reached the end of the day Friday with their panel. Are there any preliminary matters we should address before we turn to this witness? Oh, all right. Please go ahead, Ms. Fox. Oh, sorry. Ms. I need you at a microphone.
An email is going to go out today to the whole group asking that one of the partnerships, the natural resources partnerships witnesses could go tomorrow. Chad Gaines is the individual, so people should watch for that, and we'll ask for everyone's concurrence that occurred.
All right, and we do need to have a conversation about today and tomorrow. In particular, it sounds as though we have some schedule juggling. So, sir, if you would spell your first and last name.
Vidal Gonzalez, VIDAL GONZALES.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Fox.
Thank you, Madam Hearing Officer. Good morning, commissioners. I'm Tanis Fox with Western Environmental Law Center, representing water protection organizations. Mr. Gonzalez has a very brief summary of his testimony. Please state your name.
My name is Vidal Gonzalez.
What is your current employment?
I'm the Director of Policy and Planning at the New Mexico Acequia Association.
And what is your educational background?
I have a bachelor's degree in anthropology and a master's degree in community and regional planning from the University of New Mexico with a concentration in indigenous and urban planning.
Please briefly describe your work background and work you have undertaken in New Mexico.
I worked for the National Park Service, for the New Mexico Land Grant Council, and North Central New Mexico Economic Development District. While working for the New Mexico Acequia Association, I have led our work on water quality issues relating to acequias, including participating as a member of the Surface Water Advisory Panel that the New Mexico Environment Department convened, working with legislators to meet acequia policy needs in Senate Bill 21, and working on this rulemaking process.
You provided direct testimony in this matter, correct?
Yes, my direct testimony is AB-NMAA-NM Wild Exhibit 9.
Is that testimony accurate to the best of your knowledge?
Yes.
And is an accurate copy of your resume attached as Water Protection Organization's Exhibit 8?
Yes.
What are acequias?
Acequias are community irrigation systems that draw water from small mountain streams, springs, and larger rivers to provide irrigation water to historic New Mexican communities, many of which were well established before New Mexico was part of the United States through the 1848 Treaty of Guadalupe Hidalgo. Acequias are the economic and cultural bloodlines of New Mexican communities. Today, acequias are political subdivisions of the state of New Mexico, and the commissioners are tasked with maintaining these systems and ensuring that they flow with clean water for the economic and overall well-being of their communities.
What is the purpose of the New Mexico Acequia Association?
The New Mexico Acequia Association, or NMAA, is a statewide nonprofit organization with a 37-year track record of managing acequia governance and regulatory compliance, having provided direct technical and administrative assistance to over 400 acequias. The NMAA possesses specialized institutional knowledge in drafting bylaws, protecting acequia rights, executing infrastructure plans, and ensuring strict adherence to state and federal law, NMAA serves as a leading entity on the operational and statutory frameworks governing acequias in the state.
Is the New Mexico Acequia Association in support of NMED's proposed amendments to 20.6.2 and 20.6.5 NMAC as proposed to be amended by water protection organizations?
Yes, our governing body, the Congreso de las Acequias, a federation of acequias, unanimously supported the creation of a statewide water quality permitting program and the New Mexico Pollutant Discharge Elimination System in its 2024 statewide conference, which is Exhibit 18. And NMAA supports the amendments proposed set in both rules. The New Mexico Acequia Association also wishes to acknowledge the hard work that NMED management and staff have undertaken over the last several years to get us to where we are today. NMED has strongly and effectively supported funding for surface water permitting program in Senate Bill 21 before the legislature conducted extensive outreach throughout the state on SB 21 and these rules, and has met regularly with our coalition on these rules. We appreciate their hard work, their commitment to protecting water quality, and the collaboration with us.
Why are acequias supportive of the state creating a surface water permitting system?
As a result of U.S. Supreme Court decisions, including the 2023 Sackett versus EPA decision, the definition of waters in the United States has been narrowed, and those waters previously protected are no longer protected, leaving many acequias vulnerable to pollution and degradation. The potential contamination impacts these communities' economic stability and ways of life. Therefore, acequias want to protect their water so they can continue to prosper into the future.
Why are the acequias supportive of the state receiving delegation from EPA for the National Pollutant Discharge Elimination System?
Acequias will be better protected by New Mexicans who understand New Mexican customs and traditional infrastructure.
Does NMAA support including the agriculture and acequia exemptions as proposed in 20.6.2 2303 and 20.6.5 102 NMAC?
We support the agriculture and acequia exemptions as proposed by NMED because they protect our traditional ways of life and economies. They are taken directly from federal law and are designed to protect and maintain water quality in an agricultural setting.
Why is it important that the state of New Mexico establish a strong statewide surface water quality permitting program to regulate upstream discharges?
It is imperative in order to regulate upstream discharges that could contaminate acequia waters and hurt local economies while protecting acequias and New Mexican farming practices. Many springs, wetlands, and imperial streams and intermittent streams have lost their federal protection through the various Supreme Court decisions, which all contribute to downstream water quality. In creating a strong program, we can ensure pollution and sedimentation will not impact the quality of our water, economies, and traditions.
Thank you for your testimony. I move for admission of water protection organizations exhibits 8, 9, and 18.
Thank you. I'll pause for a moment in the event there are objections. 8, 9, and 18 are admitted. Thank you.
Thank you. Mr. Gonzalez now stands for cross-examination and questions from the commission.
Thank you. Will there be questions for the Natural Resources Partnership? Thank you. They declined. Mr. Stomp?
Good morning, everybody. Madam Hearing Officer, we decline also. Thank you.
I love your microphone. Yes, thank you. Ms. Taylor? Ms. Taylor declined. Mr. Parkamenko, I think I saw you on the platform.
Yes, Madam Hearing Officer, Mr. Chair, I decline at this time. Thank you.
Thank you. Let's see, Mr. Brooks or Mr. Wexler? There you are. All righty. Commissioner Zemlik, if you would.
Good morning, Mr. Gonzalez. My name is Caleb Brooks. I represent the Middle Rio Grande Conservancy District. Do you understand who I am and whom I represent?
Yes.
Mr. Gonzalez, the Acequia Association works with acequias across the state of New Mexico, including in the Middle Rio Grande Valley. Is that right?
For those acequias that are political subdivisions of the state, correct.
Okay. Are there acequias within the association operating within MRGCD's service area?
That is a complex question because MRGCD manages majority of the water for those acequias within MRGCD. So we do assist them in obtaining funding.
I believe in your written direct testimony, you supported, and in your summary today, you supported the agricultural exceptions that acequias have traditionally enjoyed from permitting requirements. Is that right?
That is correct.
Do acequia systems in New Mexico have agricultural drains?
Yes, they do flow back into the rivers and streams.
And do you agree that many acequia drains run through or alongside populated areas like small villages or alongside highways?
Yes, they do.
Do you support then MRGCD's proposal to define the agricultural return flow exception to ensure that the presence of runoff from highways or from residential areas does not disqualify a drain from the exception?
Can you state that question again?
Yeah. Yeah. Do you support MRGCD's proposal to define the agricultural return flow exception to ensure that the presence of runoff from residential areas or from highways does not disqualify a drain from the exception?
NMA hasn't taken a stance on that.
Okay. Have you looked at that at all?
Not in depth, no.
Okay. So it's safe to say then you haven't analyzed what additional burdens acequias might face if their drains require permits under the state rules?
Not in detail.
Okay. Have you reviewed MRGCD's proposed changes to the surface waters definition?
I have not.
Because acequias are in rural communities, there's often culvert crossings to people's homes, aren't there?
That is correct.
And have you looked at whether the exceptions are sufficient to prevent those rural individuals from needing to apply for permits for those culvert crossings?
Most of them are parciantes, which would mean that they have water rights and they would be able to cross that because they have water rights.
Yeah. Have you looked at whether a permit might be required under these rules?
We have not.
Okay. So it's safe to say then you don't have a position one way or the other on MRGCD's proposed changes to the exceptions for culvert crossings over irrigation ditches?
I would say we would be indifferent.
Okay. Thank you very much for your time, Mr. Gonzalez.
Thank you, Mr. Brooks. Ms. Richards? All right, Ms. Richards declined. Ms. Dolan, I think I saw you on the platform.
Yes, good morning. We also decline. Thank you very much.
Thank you. I don't know if we have Mr. Maxwell or Mr. Weatherby on the platform. Neither. All right. Mr. Kermsey. There you are. All right, Mr. Kermsey declined. Ms. Miller. Is she on the platform? No. All right. Mr. Micklejohn. All right, Mr. Micklejohn declined. Ms. Udall? No. All right. And Ms. Scott or Ms. Weatherly? Ms. Scott declines. All right. Ms. Fox, is there any redirect?
No.
All right, we'll turn then to the commission questions. We'll start at that side this time. Commissioner Zemlich, do you have questions of Mr. Gonzalez? Thank you. Commissioner Laney? No. Commissioner Langer? No. Commissioner Burunda? No. Commissioner Fry?
Thank you. I have no questions.
All
Thank you for your
right.
testimony.
Commissioner Chapman? None. Commissioner Thompson?
No questions, thank you.
All right. Commissioner Bayless?
No questions.
Commissioner Sloan? Commissioner Vihel?
No questions.
Do we have any commissioners on the platform? I think we have kind of a full house here other than, all right, and the chair said that he would be a little late this morning. So terrific. Thank you very much, Ms. Fox. Mr. Gonzalez.
Thank you.
Okay. So what makes the most sense in terms of the various juggling we're doing this morning? I mean, ordinarily we would go to the third NMED panel. Is that what makes the most sense? All righty. If you would, and you can certainly move this table perpendicular, like to make a council table up front there. Luis, would you help them with that table? All righty. Ms. Lucas, come on, would you spell your first and last name, please? Turn the microphone on.
Good morning. First name, Susan, S-U-S-A-N. Middle name, Antonia, A-N-T-O-N-I-A. Last name, Lucas Kamat, 2 words, L-U-C-A-S space K-A-M-A-T.
Do you swear or affirm to tell the truth?
I do.
Good, thank you, sir. If you would spell your first and last name.
Good morning. My first name is Nafis, N-A-F-I-S. Last name is Fuad, F-U-A-D.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead, counsel.
Good morning. Miss Lucas Kamat, will you please? Okay, it sounds very loud to me, so will this work?
Yes.
Okay. All right, Miss Lucas Kamat, please restate your name and position for the record. Good morning. My name is Susan Antonia Lucas Kamat.
I am the Point Source Regulation Section Manager with the New Mexico Environment Department, Surface Water Quality Bureau.
Can you please describe the duties associated with your position at NMED?
As the Point Source Program Manager, I manage 3 teams with 12 full-time employees that implement the permit and certification and inspection processes for discharges to surface waters in New Mexico, and I work on the development of the state permitting program. I oversee and review the certifications of over 95 National Pollutant Discharge Elimination Systems, or NPDES individual permits, 6 NPDES general permits, and 18 NPDES downstream state comments. I have overseen more than 15 anti-degradation analyses. I review compliance evaluation inspections for NPDES permits and unpermitted discharges and develop compliance and enforcement actions. I develop policy, guidelines, templates, and regulations related to point source regulation and compliance, including developing the state permitting program.
How long have you been in your current position?
I've been the Point Source Program Manager for 5 years.
Did you file a resume as NMED Exhibit 6?
Yes, I did.
Will you please give a brief overview of your relevant educational background, training, and experience?
I have a Bachelor of Science degree in Earth, Atmospheric, and Planetary Sciences, Geophysics options from the Massachusetts Institute of Technology. I also completed graduate classwork in hydrology, water resources, geochemistry, and statistics at the University of New Mexico Earth and Planetary Sciences Department. I have certification as a Geographic Information Systems Analyst, Project Coordinator, and Project Management Information Systems Specialist from the University of New Mexico. I have completed the EPA Permit Writers class, EPA Fed Talent Training for EPA Inspection Credentials, the EPA Quality Assurance Program Training, and EPA Pretreatment 101. My first job in New Mexico was at Myox Corporation, a capital equipment manufacturer of on-site mixed oxidant generators for a variety of potable and industrial water treatment applications. At Myox, I performed design review for municipal and industrial projects and prepared project plans and specifications, bid documents, design packages, and submittals for both domestic and international projects. I've been employed with the state of New Mexico since May 2005 and have held my current position with the Surface Water Quality Bureau since April 2021. During my 21 years with the state of New Mexico, I have been employed by both the New Mexico Environment Department and the Energy, Minerals, and Natural Resources Department. I began my state career as a mining geological specialist in the Mining and Minerals Division, working for 6 years on mine registrations, mine reclamation and remediation in uranium, potash, hard rock, and sand and aggregate mines, and managing the legacy uranium mine inventory project. I spent 8 years with the New Mexico Environment Department, Department of Energy Oversight Bureau as an environmental scientist, staff manager, and bureau chief. At the DOE Oversight, I performed and oversaw multimedia environmental surveillance monitoring of inorganic, organic, and radionuclide pollutants for groundwater, radionuclide pollutants for groundwater, surface and stormwater, wastewater, soil and sediment, and vegetative media. I was the NMED Risk Management Bureau Chief for 4 months, where I was responsible for the department-wide health and safety program, job hazards analysis, and loss control prevention. I was employed for 1 year by the Oil Conservation Division Environmental Bureau, where I permitted produced water, recycling facilities and containments, surface waste management facilities, and pit below-grade tanks. Since October 2020, I have been in the NMED Surface Water Quality Bureau Point Source Regulations section, first as the municipal team supervisor and then as the program manager. I have over 6 years of direct experience implementing ground and surface water protection regulations as found in 20.6.2 NMAC, and over 5 years of direct experience implementing standards for interstate and interstate surface water regulations as found in 20.6.4 NMAC.
Thank you. What is your prior experience with permitting?
At MIOX, I performed analysis on potable water plants, wastewater treatment plants, and industrial projects to comply with water quality regulations at both the state and federal level. I specifically worked with engineers and facilities to address Clean Water Act and Safe Drinking Water Act regulations. At the Mining and Minerals Division, I was responsible for the mine registration program, which is a small permitting program. Mine registration was the only mine safeguarding reclamation permitting for approximately 150 construction sand and aggregate and gravel mines and approximately 3 potash mines at the state level. I also assisted with the permit application review and reclamation inspections for hard rock mines under the Mining Act Reclamation Program and reclamation inspections for coal mines under the Coal Mine Program. At the Department of Energy Oversight Bureau, I was responsible for environmental surveillance monitoring, including surveillance monitoring for NPDES individual and general permits at both Lanil and Sandia. At the Oil Conservation Division, I was responsible for permitting recycling facility and containments, surface waste management facilities, and open pits. These permits were issued under the Water Quality Act and the Oil Conservation Act. At the Surface Water Quality Bureau, I have managed 401 certifications of EPA draft NPDES permits. I have also reviewed pesticide and pesticide applications under the Water Quality Act. I work cooperatively with the Groundwater Quality Bureau to review notice of intent to discharge. Since New Mexico does not have a surface water discharge program, which is why we developed the proposed rules, I work with the Groundwater Quality Bureau to develop surface water monitoring plans to be included in groundwater discharge permits.
Thank you. What is the nature of your testimony today?
My testimony will summarize definitions utilized throughout the rulemaking, provide a description of the New Mexico Pollutant Discharge Elimination System, NMPDES program, and its program elements, and permit conditions for point source discharges.
Did you file a pre-hearing written technical testimony as NMED Exhibit 5?
I did.
Did you file a pre-hearing written rebuttal testimony as NMED Rebuttal Exhibit 2?
Yes, I did.
Do you have any changes you would like to discuss from your written technical or rebuttal testimony today?
Yes. The department's NMED Exhibit 79A and B included several changes to definitions to be responsive to all parties' testimonies, comments, and EPA feedback. Specific to my testimony, we amended definitions found in 20.6.27 NMAC and 20.6.57 NMAC. Additionally, on my written testimony, NMED Exhibit page 12, I stated federal facilities are treated as a separate component in the NMPDES program, primarily to ensure compliance with the Water Quality Act. It should read ensure compliance with the Federal Clean Water Act and New Mexico Pollutant Discharge Elimination System Act.
Do you adopt your written technical and rebuttal testimony here today with your changes?
I do.
Okay. In your testimony, you discussed definitions that are utilized throughout 20.6.2 NMAC. Can you please summarize that testimony for each of those definitions you discuss?
The definitions in 20.6.2 NMAC provide the necessary framework to implement the state permitting program. The department proposed new definitions for compliance plan, compliance schedule, and pollutant minimization plan that provide clarity for permitting. The department proposes to change the definition of daily composite sample to allow for time compositing, flow proportion compositing, and continuous compositing that provides more options to permittees for composite sampling. The definitions for facility, general permit, pathogen, sludge, and source are already defined in the Water Quality Act. The department has modified the definitions based on State Record Center recommendations. The definitions shall have the same meaning as defined in the Water Quality Act, Section 74-6-2, New Mexico State Annotated 1978. These changes are in Exhibit 79A. The definitions for publicly owned treatment works and privately owned treatment works are consistent with 40 CFR. Based on the Natural Resources Protection testimony, the department proposes to change the definition of concentrated animal feeding operation to means an agricultural meat, dairy, egg, horse, or other non-aquatic animal operation where animals are kept and raised in confinement as specified in 40 CFR Section 122.23. This change is in NMAD Exhibit 79A.
In your testimony, you discussed definitions utilized throughout 20.6.5 NMAC. Can you please summarize that testimony for each of those definitions you discussed?
The definitions in 20.6.5 NMAC provide the necessary framework to implement the New Mexico Pollutant Discharge Elimination System Permit Program. The department proposed new definitions for Code of Federal Regulations to provide clarity for permitting. The definitions for applicant and treatment works treating domestic sewage are consistent with 40 CFR. The definitions for Federal Act, National Pollutant Discharge Elimination System, New Mexico Pollutant Discharge Elimination System Act, and pollutant are already defined in the New Mexico Pollutant Discharge Elimination System Act. The department modified the definitions based on State Record Center recommendations. These definitions shall have the same meaning as defined in the New Mexico Pollutant Discharge Elimination System Act, Section 74-6C-2, New Mexico State Annotated 1978. These changes are in NMAD Exhibit 79B.
In your testimony, you discussed definitions that are utilized throughout both 20.6.2 and 20.6.5 NMAC. Can you please summarize that testimony for each of those definitions?
The definitions in 20.6.2 and 20.6.5 NMAC provide the necessary framework to implement both the state permitting program and the New Mexico Pollutant Discharge Elimination System program. The definitions for indirect discharger and stormwater are consistent with 40 CFR. The definitions for general permit coverage, new source, and point source are already defined in the Water Quality Act. The department modified these definitions based on State Record Center recommendations. These definitions shall have the same meaning as defined in the Water Quality Act, Section 74-6-2, New Mexico State Annotated 1978. These changes are in both NMAD Exhibit 79A and B.
Can you please summarize your testimony on the NMEDES program and program elements generally?
There are 5 program elements in the NMPDES program. The 5 program elements are individual permits, general permits, federal facilities, pretreatment, and biosolids. There are 2 basic types of NMPDES permits, individual permits and general permits. An NMPDES permit is typically an authorization for a facility to discharge a specified amount of pollutant into a receiving water under specific conditions. Permits may also authorize facilities to process, incinerate, landfill, or beneficially use sewage sludge. As stated by Ms. Lemon in her cross-examination, the 5 NMPDES program elements are phased in during the implementation of the NMPDES program for the NMAD application to EPA for Clean Water Act delegation. For implementation, NMAD can phase in the 5 specific elements or we can phase in the specific elements and sub-elements. For example, we could phase in wastewater treatment plants, individual permits, and pre-treatment in year 1, individual permits, industrial wastewater treatment plants, and industrial stormwater in year 2, construction and municipal stormwater in year 3, federal facilities and all other individual and general permits in year 4, and biosolids in year 5. And that was just an example. We could mix and match them as we see fit.
Can you please discuss the NMPDES individual permit program?
An individual permit is developed specific to a facility or treatment works based on the facility function, effluent quality, and the receiving water designated uses and ambient water quality. An individual permit is developed based on the information contained in the permit application, receiving water information collected by the department, and water quality standards in 20.6.4 NMAC. Based on the site-specific generation, the department drafts a permit with both technology-based effluent limits, TBELs, and water quality-based effluent limits, WQBELs. Permits are of a specific time period, not to exceed 5 years, with a requirement for the facility to reapply prior to the permit expiration date.
Can you please discuss the NMPDES general permit program?
A general permit covers a group of discharges with similar qualities within a specific geographical location. General permits offer an efficient, cost-effective alternative to individual permits by providing permit coverage to multiple facilities with similar functions operations that can be covered under a single permit. General permits often utilize best management practices, BMPs, to ensure water quality standards are met. Permits are for a specific time period, not to exceed 5 years, with a requirement that the facility reapply during a time period around the permit expiration date.
Can you please discuss the NMPDES federal facility permit program?
A federal facility status as part of the federal government makes their compliance reporting and regulatory oversight distinct from other public and private entities. Federal facilities are treated as a separate component in the NMPDES program, primarily to ensure compliance with the Federal Clean Water Act while navigating the complexity of federal sovereignty, accountability, and unique operational activities. Federal facilities often conduct unique activities that require specialized pollution prevention plans and unique stormwater management strategies. The proposed rule requires federal agencies to comply with the NMPDES requirements regarding water pollution control through individual and general permits. Federal agencies are not exempt from NMPDES permitting, monitoring, and reporting.
Can you please discuss the NMPDES pre-treatment program?
The pretreatment program prevents harmful industrial pollutants from entering publicly owned treatment works, POTWs, protects POTW infrastructure, and reduces the conventional and toxic pollutants levels discharged by industries into municipal sewer systems and the environment. Core components of a pretreatment program include legal authority, which is usually a local sewer ordinance, industrial permits for indirect dischargers, local limits, prohibitions, categorical technology-based standards for specific industrial categories, monitoring inspections, enforcement, and pollution prevention in BMPs.
Can you please discuss your testimony on NMPDES biosolids?
There are generally 3 options for use and disposal of sewage sludge, also known as biosolids: land application, landfilling, and incineration. Facilities are required to summarize their sewage sludge management practices and provide pollutant monitoring data in the biosolids annual reports, or BARs. A bar is required from a POTW that land applies, incinerates, or disposes of its sewage sludge via surface disposal.
Can you please summarize your testimony on the permit conditions for point source discharges generally?
My testimony details the specific permit conditions for all NMPDES and state surface water permits and point source discharge permits to protect surface water quality. The conditions apply to both individual permits and general permits. Permittees must comply with all permit conditions.
Please discuss your testimony on standards for interstate and intrastate surface waters.
Both individual and general permits must comply with the water quality standards found in 20.6.4 NMAC, standards for interstate and intrastate surface waters. This is accomplished by including permit conditions and including water quality and technology-based effluent limits.
Can you please discuss surface water quality protections?
The proposed regulations require monitoring, reporting of water quality, and assessment of best management practice effectiveness, including the retention of monitoring data records. If monitoring shows that a point source permittee is out of compliance with water quality standard, the proposed rule allows for the submittal of a compliance plan, compliance schedule, and/or a pollution minimization plan.
Can you please discuss sampling and analysis?
The department proposes that sampling and analysis follow the requirements outlined in 20.6.414 NMAC to ensure high-quality, repeatable data. 20.6.4.14 NMAC includes references and instructions for sampling and analytical techniques, bacteriological surveys, sampling procedures, toxicity monitoring EPA methods, and emerging contaminants monitoring.
Can you please discuss your testimony on notification of individual facility operational changes?
Changes in individual facility operations can affect effluent characteristics. The department will use notifications of any facility expansion, process modification, or design flow increase to determine if there will be a change in the discharge quality or quantity, which may result in a permit modification, revocation, or termination.
Please discuss notification of general permit facility operational changes.
Project expansion or modification for facilities with a general permit may result in water quality changes, and the facility may no longer meet general permit coverage requirements. Notification will allow the department to modify, revoke, or terminate the general permit coverage and require individual permit coverage as needed.
Can you please discuss notification to downstream Indian nations, tribes, and pueblos and states?
The department proposes to notify any downstream Indian nation, tribe, and pueblo of New Mexico of any permit applications or modifications that may affect the quality and quantity of discharge. This includes discussion of any Indian nation, tribe, or pueblo water quality standards. This also applies to downstream states.
Can you please discuss your testimony on permit conditions for all surface water permits?
The proposed permit conditions are modeled on conditions in EPA MPDS permits. The permit conditions include a duty to comply, duty to reapply, duty to avoid, minimize, and mitigate, duty to provide information, and duty to provide notice. The proposed permit conditions also include requirements for proper facility operations and maintenance, including monitoring requirements and record retention, reporting requirements, and signatory requirements. While a surface water quality permit does not convey a property right, facilities are required to allow for inspection and entry.
Can you please discuss your testimony on permit conditions for point source permits?
The department proposes the requirement of technology-based effluent limits for certain effluent limits at POTWs based on secondary treatment requirements found in 40 CFR Part 133. Effluent guideline limitations found in 40 CFR Chapter 1, Subchapter N apply to all non-POTWs. Permit conditions may be based on total maximum daily loads, waste load allocations, the water quality standards, the state's anti-degradation policy, and anti-backsliding. Specific conditions for agriculture and cooling tower intake structures for new facilities are included to protect water quality in designated uses.
Thank you. Is there anything else you would like to discuss here today?
No.
Thank you. No further questions. Ms. Lucas, come on.
Thank you.
And I'd like to call our next technical witness, Dr. Nafis Fawad. Will you please restate your name and position for the record?
Good morning again. My name is Nafis Fawad, and I'm currently employed as the inspections team supervisor.
And can you please describe the duties associated with your position?
Sorry, was I speaking to her?
Hear anything.
Got it.
I apologize. I moved the microphone. I apologize.
Oh, that's
I noticed you, so I'll repeat again. My name is Nafis Fawad. I'm currently employed as the inspections team supervisor at the department's Surface Water Quality Bureau.
And can you please describe the duties associated with your position?
I serve as a Clean Water Act inspector. I provide technical assistance to NPDES permittees and responsible parties for unpermitted discharges and spills. I serve as agency lead representative and interact with several entities outside of NMAC, including scientific and regulatory entities, stakeholders, landowners, and industry regarding compliance and enforcement of surface water protection.
Oh, I'm sorry, Kim. Sorry for the interruption. Please go ahead.
And how long have you been in your current position?
I served in this position for 2.5 years as of June 8, 2026.
Did you file a resume as NMED Exhibit 8?
Yes.
Would you please give a brief overview of your relevant educational background and training?
I hold a Bachelor's of Science degree in Civil Engineering, a Master's of Science degree in Water Resources Engineering and Management, a Master's degree in Infrastructure and Environmental Engineering, and a Doctor of Philosophy degree in Environmental Engineering. My doctoral dissertation research was focused on metal uptake and toxicity to aquatic organisms, which is related to water quality standard development. I have instructed environmental chemistry in my program at the University of Connecticut and assisted in instructing several other environmental engineering courses in several institutes. I am a registered professional engineer in New Mexico. I am a US EPA credentialed non-federal Clean Water Act inspector.
Can you please expand on your experience with NPDES?
I am trained and regularly conduct all kinds of NPDES compliance evaluation inspections, including wastewater, stormwater, sanitary sewer overflow, concentrated animal feed operations, and aid federal inspectors, including US EPA Region 6 and National Enforcement Investigation Center, NEIC, in inspections and audits of NPDES permittees. I review data submitted by NPDES permittees. I aid the US EPA in NPDES enforcement actions. I prepare state certification pursuant to Section 401 of the Federal Act. I provide compliance assistance to NPDES permittees.
What is the nature of your testimony today?
My testimony covers the following topics regarding the rules being proposed by the department: surface water permits, the surface water permit and administrative permitting process, and permit compliance and enforcement.
Did you file written technical testimony as NMED Exhibit 7?
Yes.
Did you file written rebuttal testimony as NMED Rebuttal Exhibit 3?
Yes.
Do you have any changes you would like to discuss from your written technical or rebuttal testimony?
Yes. As BO Chief Lemon discussed, we are considering proposing a few changes in 20.6.2, 2308, and 0.2309, as well as 20.6.5401 and 0.402 NMAC.
And do you adopt your written testimony with those changes here today?
Yes.
In your written testimony, you discussed the need for permitting programs in the state. Can you please summarize that testimony?
In my testimony, I discussed the department lacking a permitting program for surface water of the state. I also discussed the permitting program of the United States Environmental Protection Agency and the department's role in permitting some of those waters, also jurisdictional under the Federal Clean Water Act, which are also known as waters of the United States.
In your written testimony, you discussed the proposed state surface water permitting program. Can you please summarize your testimony on individual and general surface water discharge permits and general permit coverage?
In my testimony, I discussed requirements and processes for receiving applications for individual surface water discharge permits by the department. I also discussed the qualifying categories of discharges and requirements for general permits, along with the process to request coverage under those permits. These requirements and processes are in 20.6.2, 2304 through 0.2306 NMAC.
Can you please summarize your testimony on the permit process for individual surface water discharge permits under the state surface water permitting program, starting with the application process?
In my testimony, I discussed the application process to obtain a new individual surface water discharge permit, or to renew, modify, revise, or transfer an existing surface water discharge permit, including the format and the payment requirements. These requirements are in 20.6.2, 2304 NMAC. As BO Chief Lemon discussed, we are now proposing a process for requesting a permit requirement determination to the department. Within 30 days, the department shall make a determination or request further information if necessary. If further information is requested, the requester shall have 30 days to respond. If a permit is required, the department has 30 days to review, determine, and notify administrative completeness of an application. In case the application is incomplete, the notification informs the deficiencies and required additional information and sets the deadline for submission. If the information is overdue, the application shall be considered as withdrawn. The department may inspect to collect information as a part of the application. These processes are in 20.6.2, 2308 NMAC. We are also proposing that the administratively complete determination shall include a determination of the applicable fee for the permit. In my testimony, I discussed the department's timeline of 150 days to process an application, which includes a few steps I will discuss further.
Can you please summarize your testimony on the permit process regarding the department's processing of applications, starting with the recommendation to issue a permit?
The department has 90 days for the first step to draft a permit or to draft a notice of intent to deny or to terminate a permit. The department may request additional information if necessary, which will pause the processing timeframe temporarily. Depending on the department's decision, it shall prepare fact sheets or statement of basis containing explanation, conditions, and justification for the conditions. The Secretary may consult with certain state or federal agencies and may reflect their views in the process. These processes are in 20.6.2, 2309, and 0.23010 NMAC.
Can you please summarize your testimony on the permit process regarding public notice and public hearings?
In my testimony, I discussed the requirement for the department to provide public notice for any draft individual permit. Concurrently, the applicant also has the obligation to provide public notice of the draft permit, including proof of that to the department. I also discussed the requirement for the department to provide 30 days from the public notice to receive written comments and public hearing requests. If a public hearing is held, the public comment period shall extend to the close of the public hearing. These requirements are in 20.6.2, 2311 NMAC. My testimony discussed the department's deadline and administrative requirements for giving notice of the hearing when warranted or required. The hearing officer shall issue a report which may include findings of facts, conclusions of law or discretion, and reasons within 30 days after the closing of the hearing record. These processes are in 20.6.2, 2312, and 0.2313 NMAC.
Can you please summarize your testimony on the permit process regarding preparation of the final draft permit and the Secretary's decision?
In my testimony, I discussed the department's requirement to prepare a final draft discharge permit based on all available information, including any public comment provided, testimony, or associated hearing officer report, and post-hearing submissions. Within 30 days after the final draft individual permit is provided for the review, the Secretary shall take final action and notify the applicant or permittee and persons who participated in the permitting action. These requirements are in 20.6.2, 2314 NMAC.
Can you please summarize your testimony on the appeal processes regarding final draft permits?
In my testimony, I discussed the two processes of appealing the Secretary's final action to the Commission for review and appealing the Commission's decision for judicial review. These processes are in 20.6.2, 2316, and 0.2317 NMAC respectively. The Secretary's decision can be appealed to the Commission for review. The filing of an appeal shall not act as a stay any provision of the Water Quality Act, the rules, or any permit issued pursuant to the Water Quality Act, unless otherwise ordered by the Secretary or the Commission. A discharger may appeal certain determinations by the Secretary to the Commission within 30 days after receiving the Secretary's written determination. An applicant, permittee, or a person who participated in an individual permitting action and who is adversely affected by such action may appeal the decision of the Commission to the Court of Appeals.
Can you please summarize your testimony on the permit process for general surface water discharge permits under the state program?
In my testimony, I discussed the permit process for general surface water discharge permits, which is very similar to the process for individual surface water discharge permits, as I summarized just now. I'll point out the key differences between the two. For general surface water discharge permits, there is no application process involved. The department may recommend issuance of a draft general permit or modify or renew a general permit. The draft general permit modification or renewal shall also contain all conditions required pursuant to section 20.6.2, 2307 NMAC. Similar to an individual permit, the department shall prepare a fact sheet or any draft general permit provision explaining conditions, explanations, and justifications. For a notice of intent to terminate a general permit, the department shall prepare a statement of basis explaining the reasons. These processes are in 20.6.2, 2310 NMAC. For general permits, the department shall provide public notice of the draft general permit. Similar to the public notice for an individual permit, this notice shall include certain discharge and administrative information, but only those applicable to the covered activity. This process is in 20.6.2, 2311 NMAC. The public hearing process for general permits is the same, except that the general permit, for the general permits, the hearing shall be held in the affected region, basin, or watershed, or in Santa Fe if the general permit applies statewide. This process is in 20.6.2, 2312, and 2313 NMAC. The secretary review and approval process for the general permits is the same with two exceptions. One is that the secretary has 45 days to complete the review and approval process from when the department provides the secretary with the final draft of the permit. And the second is the general permits may be issued for fixed terms up to 10 years. Additionally, the secretary may terminate a general permit if it is if it's determined that the activities authorized by the general permit have an adverse impact on the environment, endanger human health or the environment, or such activities are more appropriately authorized by an individual permit. The process for secretary's review and the final action is in 20.6.2, 2315 NMAC. The process for appealing the secretary's decision to the commission and the commission's decision for a judicial review is the same as individual surface water permits and are also in 20.6.2, 2316 and 0.2317 NMAC respectively. In my rebuttal testimony, I discussed the additional language proposals for section 20.6.2, 2304E NMAC regarding the conditions for termination of individual permits in Rachel Kahn's direct written testimony submitted on behalf of the water protection organizations. The suggested language is not consistent with the process for an individual's surface water permit for a discharge. The NMAD proposed language is consistent with the federal NIPTES program and the department's proposed NMPDS process in 20.6.5, 301E NMAC.
In your written testimony, you discussed the New Mexico Pollutant Discharge Elimination System program. Can you please summarize that testimony?
In my testimony, I discussed mechanisms provided by the Federal Clean Water Act for states to establish and administer a National Pollutant Discharge Elimination System, NIPTES permit program. Consistent with the NMPDS Act, the proposed new rule prohibit, except as provided in the exemptions, any discharge of pollutant to waters of the United States from a point source without an individual permit issued by the department or general permit coverage approved by the department. In my rebuttal testimony, I acknowledged the request in Daniel Sharin's direct written testimony submitted on behalf of the Albuquerque-Bernalillo County Water Utility Authority to include a provision to modify individual permits for the federal regulations, and I express the department's commitment to incorporate the request. This provision was incorporated in 20.6.5 301D NMAC in NMAD Exhibit 79B.
Can you please summarize your testimony on the permit process for individual NMIPD's permits?
Similar to the US EPA and the state permitting program under the authority of the Water Quality Act, the department shall require any person who requires a new individual permit or a renewal, modification, or transfer of an existing individual permit to submit an application. As we are now proposing, the determination of permit requirement process is the same as the state permitting program. In my testimony, I discussed the individual NMPDS process starting with a 30 days administrative completeness. The timeline may be paused or the application may be terminated for administratively incomplete new applications depending on the applicant's response. I discussed the requirements for submitting renewal NMPDS permit applications and the scenarios if the department does not issue a renewal permit before the expiration of the existing permit for both administratively complete and incomplete applications. I also discussed the additional requirements for renewal permits if a permittee with an existing permit is out of compliance. These processes and requirements are in 20.6.5 401 NMAC. Consistent with the individual surface water permitting process I summarized earlier, the department has 150 days to process an administratively complete application after the receipt of applicable fees, unless a public hearing is involved. Within this timeline, the department has 90 days to make the recommendation on issuing either a draft permit, a notice of intent to deny the application, or when applicable, a notice of intent to terminate a permit by denying renewal. Consistent with the federal regulations, any draft permit shall include either a fact sheet or statement of basis, including the principal facts, considerations, and other information. The department may request additional information, which shall temporarily pause the processing timeframe. The department may consider information collected during inspections or consulting with certain state or federal agency or the government of any New Mexico's nation, tribe, or pueblos as a part of the application. These processes are in 20.6.5.402 and 0.403 NMAC. Similar to the individual surface water permitting processing, after making a recommendation, the department shall provide public's notice of the applicable draft permit or applicable notice of intent, along with the fact sheet or the statement of basis. In addition to and concurrently with the department's public notice, the applicant for an individual surface water discharge permit shall be required to provide notice to the public following certain requirements. Following public notice of a draft permit, the department shall provide at least 30 days for receiving written public comments. The department may extend the public comment period upon written request or to the close of the public hearing if a public hearing is held. These requirements are in 20.6.5.404 and 0.405 NMAC. In my rebuttal testimony, I discussed the additional language proposals for sections 20.6.5404B NMAC in Rachel Kahn's direct written testimony submitted on behalf of the water protection organizations. This proposed additional language is regarding requirement for the department to publish public notices in specific sections for specific news media. Pursuant to the federal regulations, in lieu of the requirement for publication of a notice in a daily or weekly newspaper, the department has selected the option to publish all notices of activities to the department's public website. This option provides flexibility and significant cost savings for the department while meeting the federal requirements for public notices of public permit actions. Under certain criteria, the department shall hold a public hearing with notice of the hearing at least 30 days prior. The requirements and the procedure for public hearing are consistent with that of the individual surface water permit processing and are in 20.6.5406 NMAC. Following the public notice period and any public hearing, the department shall prepare a draft permit considering all information available. Again, for these permits, the Secretary has 30 days to take the final action and to notify of it. In the Secretary's discretion, a new, renewed, or modified permit may include conditions requested by certain state or federal agencies. NMPDS permits shall only be effective for a fixed term of maximum 5 years. A new, renewed, or modified permit shall become effective 30 days after the department gives notice of to the applicant, unless a later date is specified in the permit or a timely petition for review is filed. This process and associated requirements are in 20.6.5.407 NMAC. The processes for appeals to the NMPDS, appeals of NMPDS individual permits to the Commission and to the New Mexico Court of Appeals are the same as those in 20.6.2. These processes are under 20.6.5408 and 0.409 NMAC.
Can you please summarize your testimony on the permit process for NMIPD's general permits?
In my testimony, I discussed the categories of discharges for which the Secretary may issue or renew a general permit as described in the Code of Federal Regulations for either stormwater point sources or other point sources or treatment works treating domestic sewage. If all the sources in the category or subcategory satisfy the federal regulations. If a facility within the category or subcategory is covered by an individual permit, the facility shall not be covered by a general permit. The Secretary may modify, revoke, and reissue, terminate, or deny renewal of general permit on their own or at a written request for a reason specified in the federal regulations. If the Secretary decides that such a request is not justified, they shall send the requester a brief written response giving a reason for the decision, which shall not be subject to public notice, comment, or hearing. If the Secretary does not renew a general permit before its expiration date, the current general permit shall be continued and a permittee who has a general permit coverage shall continue to comply with the general permit until either the permittee submits a notice of intent for general permit coverage under the renewed general permit, or the permittee obtains an individual permit, or a coverage under the general permit is terminated. These processes are in 20.6.302 NMAC.
Can you please summarize your testimony on the process for coverage under surface water general permits and NMIPD's general permits?
In my testimony, I discussed the process of obtaining coverage under the NMPDS permit general permit. Within a specified deadline, eligible persons are required to submit to the department a notice of intent, or NOI, with all the required information to obtain a coverage under a general permit. If any person who is eligible for coverage under a general permit is not covered, and the person discharges to waters of the United States, the discharge shall be deemed unauthorized, and the person shall be deemed in direct and immediate violation of the Clean Water Act. The department shall have 15 days to review any notice of completeness. Notice of intent for completeness. If a notice of intent or NOI is complete, the department shall proceed with assessing whether an activity meets the terms and conditions of the general permit. If the NOI is not complete, the department will notify the applicant of the deficiencies, what information is required, and a deadline to submit the additional information. The department shall deem the NOI to be withdrawn if the applicant fails to correct the deficiencies within the timeline. The department shall have 30 days after determining the NOI is complete to make a determination regarding general permit coverage authorization at its sole discretion and notify the applicant. A general permit coverage can be transferred to another person by submitting a notice of termination and a notice of intent by the permittee and the transferee, respectively. Until the complete transfer notices are sent by the department, the authorization and the responsibilities regarding the coverage stays the same. The permittee may request to terminate its general permit if discharge-related activities have ceased and termination conditions have been satisfied. The general permit coverage is being transferred or the discharge has been terminated. The department shall have 30 days to approve or deny the notice of termination. The Secretary may terminate general permit coverage for any reason listed in the federal regulations, or if the permittee violates any provisions of the NMPDS Act or any applicable rules, standards of performance, or water quality standards, or any applicable state, federal, or tribal effluent regulations or limitations. General permit coverage shall terminate automatically when the department issues an individual permit for the general permit covered activities or practices. For certain reasons consistent with the federal regulations, the Secretary may require, in writing, including reasons and procedures, a person seeking general permit coverage to obtain an individual permit on their own or at the written request of any person. This decision shall not be subject to public notice, comment, or hearing. Failure to submit an administratively complete application by the initial or extended deadline, the general permit coverage shall be automatically terminated. This process is parallel to that for the state permitting program. In my rebuttal testimony, I discuss additional language proposals for section 20.6.2, 2304, E NMAC, and 20.6.5, 303, C NMAC in Rachel Kahn's direct written testimony submitted on behalf of the water protection organizations. This proposed additional language is regarding provisions to allow a person who participated in the permitting action and is adversely affected by the department's determination of authorization eligibility for coverage under the general permits to appeal the decision to the commission. The department already has proposed provisions to allow appeals to what is a permitting action. Authorization under a general permit coverage is not a permitting action. This proposed additional language does not align with the Water Quality Act or the NMPDS Act.
In your testimony, you discuss compliance and enforcement under the NMIPD's program. Can you please summarize that testimony?
In my testimony, I discuss what constitutes compliance, processes for investigations, compliance evaluations, and enforcement actions. The department may use credible information obtained from a third party or compliance with the provisions of this rule, or from a nation, tribe, or pueblo government or agency indicating on compliance with the provisions of the tribal water quality standards or evaluating compliance. These provisions are in 20.6.5.501.
Is there anything else you'd like to add to your testimony today?
No, this concludes my testimony.
Thank you, Dr. Fawad. I have no further questions.
Thank you so much. I believe this might be a good time to take our morning break. Oops, sorry. So if we come back, let's say 10:40. When we broke, the third NMED panel had completed their testimony summary. I see Mr. Boutier in the cross-examining attorney's seat. Mr. Boutier?
Thank you, Madam Hearing Officer, members of the commission. Is that too loud? My name's Stuart Boutier. I'm with the Modrell Sperling Law Firm, and I'm one of the counsel representing the Natural Resources Partnership. Thank you, Dr. Fawad and Ms. Lucas Kamat for your important testimony today. I have some questions that I hope will sort of orient us in the room to what we're doing, why we're here, and then I'll get into some of the specifics. Let me start with you, Dr. Fawad. Am I correct that on page 1 of your direct written testimony that you identify the statutory bases for this rulemaking?
Yes.
And I intentionally use the term bases to indicate that there are two separate statutory bases for this rulemaking. Would you agree with that?
Yes.
And one is the NMPDES Act, which is the act that proposes to seek primacy over the Clean Water Act Section 402 program, correct?
Correct.
And the other is comprised of amendments to the Water Quality Act to adopt rules relating to a state surface water permitting rule, correct?
Correct.
And consistent with the fact that there are two separate statutory bases for this rulemaking, am I correct that there are essentially two sets of proposed rules that are sought to be adopted, that the department seeks to have the commission adopt as part of this proceeding?
Yes. One, a new rule at 20.6.5, and the second, the amendments to the existing rules at 20.6.2.
Okay, thank you. The neither of those rules that are required to be adopted by the commission have to be adopted by a particular date. Am I correct about that?
I am not sure on that.
Well, I would represent to you that there's no specific deadline by which the commission needs to adopt either the NMPDES rules or the surface water permitting program. Does that sound like something you would agree to, or just?
So it would have been specified in those acts, and I'm not
Okay.
I don't remember. So if you say that they're not there, then I'll agree with that.
And let me then ask Ms. Lucas Kamat, is that your understanding that there's no deadline by when this commission needs to adopt an NMPDES set of rules seeking primacy over the Section 402 Clean Water Act program, and there's no specific deadline by which this commission is instructed by the legislature to adopt a state surface water permitting program?
To the best of my recollection, the amendments to the Water Quality Act and the New Mexico Pollution Discharge Elimination System Act did not have deadlines for when the rules had to be promulgated.
Thank you. And either of you, would you also agree that there's no specific effective date that the legislature required for either of the rulemaking proposals that are combined into this rulemaking?
To the best of my memory, there was no date in Senate Bill 21 for when the rules had to be promulgated.
And in fact, am I correct that due to the primacy seeking overlay associated with seeking primacy under the NMPDES program, that the two separate rules that the agency is asking the commission to adopt will play out on different timelines? Is that a fair statement?
That is a fair statement.
Okay. And there's no reason to think that the two programs need to be adopted at the same time, nor have the same effective date, correct?
While the programs do not need the same effective date or need to be adopted at the same time, the Clean Water Act delegation, part of our application requires that we show we have the capability and build out to implement that program. And so building the state program can be used to show that we're ready for implementation under the New Mexico Pollutant Discharge Elimination System.
Thank you. And in your testimony this morning, Ms. Lucas Kamat, you identified the 5 elements of the NMPDES program as you sort of categorize them, correct?
I identified the 5 elements as EPA defines them. Yes.
Okay. And am I correct that all 5 of those elements are necessary before the EPA would approve of primacy over the Clean Water Act Section 402 program?
We have to include in our memorandum of agreement how we're going to implement the 5 programs. We do not have to implement them until the dates that are established in that memo of agreement.
Okay, thank you for that clarification. So it may be that EPA can approve of your plan to implement those 5 elements of the program, but they need not necessarily each have been implemented by the time primacy is sought and EPA approves primacy.
Can you rephrase or restate the question?
Sure. So I think I understand I was trying to rephrase your testimony. I think that I understand your testimony to be that NMED could come up with a plan to implement the 5 elements, Clean Water Act required elements of the NMPDES program over which the state is seeking primacy. But not every one of those components needs to actually have been implemented at the time that the agency seeks primacy and or receives primacy from EPA, correct?
Correct.
Okay. So it could happen before all 5 of those elements have been implemented. By it, I mean EPA could approve primacy,
right,
assuming the other criteria and requirements to get primacy have been met.
Right. EPA could approve delegation under the Clean Water Act based on the timeline and the items and the implementation steps included in the memorandum of agreement and application to EPA.
Okay. Now, Ms. Lucas Kamat, Am I saying your name correctly? Just to be safe.
You're close enough.
Close enough?
Yeah.
Thank you. Am I correct that, well, you testified that you were involved in the development of this rulemaking, correct?
Correct.
And did that include development of the legislative strategy that NMED pursued in order to seek bills to be passed by the legislature?
I was involved in the development of the statutes, yes.
And that also includes the decision-making to include both of these separate rules in one rulemaking, the MPDES primacy rule and the state surface water rule. Is that correct?
Yes.
And in fact, you identify on page 10 of your written direct testimony the basic logic and rationale for this rulemaking. Is that correct? Bottom half of page 10 of your NMED Exhibit 5.
Yes, that is correct.
And you indicate that New Mexico needs a state-led MPDES program to close regulatory gaps caused by federal Clean Water Act changes, which removed protection for many of the state's ephemeral and intermittent waterways. Did I read that correctly?
Yes, you did.
Okay. Is it your testimony that seeking and getting primacy of the MPDES program is a necessary prerequisite to close the regulatory gaps? And I assume by the regulatory gaps, we're talking about the scaling back of WOTUS under Sackett and earlier decisions from the U.S. Supreme Court, correct? Let me break that down. That was a compound question. When you refer in that sentence that I just read to closing regulatory gaps, you're talking about the concern that NMED has that certain state surface waters are no longer protected and are exposed because of the scale back of the coverage of WOTUS at the federal level.
Correct. Like I call it a WOTUS whiplash over the last decade, that it's unclear which way the water is flowing sometimes.
Well, that's a great point. And I think some testimony has come out that may suggest that there's been a gradual scale back of WOTUS. In fact, I like your terminology better, which is whiplash, because in fact, it's sort of fluctuated over time, correct?
Correct.
And that's from the early 2000s forward?
Correct.
Okay. Would you agree with me that if this commission decided it wanted to proceed first on the state surface water permitting program, that would be the mechanism to close the gaps after WOTUS and Sackett after Sackett decision from the Supreme Court scaled back the coverage of WOTUS?
It would be one way to close the gaps, yes.
Okay. And would you also agree with me that actually having primacy over the MPDES program is not a prerequisite for this commission to adopt a state surface water program?
It is not.
The two are quite distinct, right? The seeking of primacy under the MPDES program and the adoption of a surface water permitting program.
They're two different actions, but they require the same lift or level of effort.
Okay. So in your involvement in developing the statutory strategies, as well as the strategy for combining into a single rulemaking both the MPDES component and the surface water permitting program, was there any consideration given to the possibility of pursuing these programs in sequence? In other words, either start with the MPDES primacy program or the state surface water permitting program, or vice versa?
We looked at the fact that a state permitting program and a New Mexico pollutant discharge elimination system delegation program were both options. We went with combining them because the level of effort required in a rulemaking, the level of effort in a statutory change, it's the same level of effort. So it was determined this was more the word is escaping me right now, but it was the same amount of work to do both, where it would be not quite double the amount of work to do them separately.
Was part of the rationale that sort of there was an economy of scale to seek both programs in a single rulemaking?
Yeah, there was economy of scale. We could do one rulemaking. We could do one, even one statutory presentation. We could do one advisory panel.
Okay. And while we're on the advisory panel, am I correct that you were present throughout the 6 or so days of surface water advisory panel process?
Yes, I was.
And that was conducted in Albuquerque?
Yes, it was.
And in fact, I was a part of that panel representing one of the representatives of the New Mexico Mining Association.
Yes.
Did you review the New Mexico Mining Association's written proposal or comments that came after those 6 days of proceedings?
Yes.
And do you recall that it was the New Mexico Mining Association's proposal to take these rules one at a time?
I do not remember explicitly, but if you say they were, I would agree to that.
I will represent that that was one of the significant comments. But I will also say that at the time, knowing what we did at that time and maybe not what we know now, the proposal was to take the MPDES primacy step first and then only then proceed to the state surface water permitting program. Do you recall any discussion about those types of comments and the suggestion from the regulated community to take up these rulemaking proposals one at a time?
I remember comments. I do not remember the specifics.
Okay, thank you. The primary motivation for the rule that we're here today to talk about is really to close the regulatory gaps after Sackett and perhaps earlier renditions of decisions from the U.S. Supreme Court addressing WOTUS, correct?
Partially, yes.
Wouldn't you agree with me that that's the primary reason we're here, is to make sure that the exposed state surface waters, at least from the perspective of the agency, need to be taken care of so that they're not polluted, essentially?
That is the main reason. There's also a slight nuance which led us to take both rules at once, which was based on comments also from the regulated industry, that with the WOTUS whiplash and moving between two permitting programs, to have some consistency so that the regulated community itself had some consistency of, regardless where WOTUS was, the rules would be similar enough that you could move through them.
Well, thank you for that. And isn't it the case that essentially WOTUS will be WOTUS based upon federal determinations of the extent of Clean Water Act jurisdiction?
Yes, WOTUS is called out in the Clean Water Act.
And would you agree that no matter what the commission does in this proceeding, it cannot affect how the federal U.S. Supreme Court and the agencies administering the federal Clean Water Act program conceive of and define WOTUS?
Correct.
Okay. Now, the Clean Water Act has two main permitting programs associated with it, correct?
Are you referring to the EPA 402 and the Army Corps 404?
I am.
Okay, yes.
So, and just to orient ourselves, the 402 is the MPDES program at the federal level that would apply to federally determined WOTUS.
Correct.
And the Section 404 dredge and fill permitting program administered by the Army Corps of Engineers is a separate permitting program that similarly has a scope defined by federal law, in other words, WOTUS, correct?
To the best of my knowledge, I do not think I testified to the Section 404 program.
Understood. And I'm just trying to understand the motivations here. But it is the case that this rulemaking only seeks primacy over the Section 402 program, the MPDES program, correct?
Correct, because out of all the states, there are only 3 that don't have NPDES delegation, us, New Hampshire, and Massachusetts. Under the Section 404, there are only 2 states that have delegation.
Okay. Well, that's helpful to know. I was not aware of that, and I appreciate that testimony. The fact, though, is that the state did not seek primacy over the Section 404 dredge and fill program administered by the Army Corps of Engineers, correct?
Correct.
But it is seeking, as part of this sort of 2-part rulemaking, primacy over the Section 402 program.
Correct.
Okay. In your discussions, and this may be implicit in the answer that you gave already, in your discussions about the development of New Mexico's program, was there any discussion or rationale offered for why the agency would not want to seek primacy over the Section 404 program?
So I did not testify to that, so I cannot speak to that.
And you were present when Ms. Shelley Lemon testified that apparently Region 6 of EPA has, for some period of time, wanted New Mexico to start the process to seek primacy over the Section 402 program.
Correct.
Is that the primary motivation for why the state is seeking, as part of this 2-part rulemaking, primacy over the MPDES program?
It is not the primary motivation. Our primary motivation is a desire to have delegation. MPDS permits should be written by people who live in New Mexico, who understand our water quality. I shouldn't have to explain to a permit writer what a monsoon is and how that affects water flows. I shouldn't have to explain our specific hydrology here, or even we know where our rivers flow. So that's been our driver.
And that concept that you just outlined there, thank you for that testimony, is more or less captured in the next sentence of your statement behind the logic of this program, correct? And that sentence reads, a state program allows local control over water quality, ensuring better protections for aquatic resources. A state-led program brings in-depth local knowledge of New Mexico's unique water systems and facilities, improving upon federal oversight. Would you agree with that?
Yes.
Thank you. Now, the same rationale that applies to thinking that local expertise is appropriate for the administration of the MPDES program would apply to the 404 dredge and fill permit program, would it not?
Again, I didn't testify to the dredge and fill.
Okay. But it is the case that no primacy is being sought in this proceeding over the 404 program.
Correct. We are not seeking primacy over the 404 permit program.
Focusing then on the part that you are more involved in terms of the development of this rulemaking request, the 402 program is you consider to be an important part of today's or of this proceedings request, correct?
Correct.
And what can you give me an idea of whether there have been notable, apart from WOTUS, whether there have been notable problems associated with the NPDES program being administered by EPA at the federal level.
I wouldn't say there have been problems, but there have been issues or hiccups dealing with the variability of water in New Mexico, having to explain our hydrology. There have been issues determining stream flows. There have been issues on the compliance and enforcement side, having to get EPA out here for inspections, just local knowledge by the permit writers of what our waters look like.
Okay, so if I can sort of restate that answer, there have been sort of practical motivations for why it would make sense for NMED to ask this commission to allow it to seek primacy from the EPA over the 402 program.
Correct.
But those are those administrative hiccups, I think it was your term, those are of a completely different scale than the gaps in surface water protection left after the scale back of WOTUS in the Supreme Court Sackett decision, correct?
I don't know if I would say they were a different scale, because they're more than administrative. They can cause serious, some of those issues have caused serious public comment, serious public concern. So I wouldn't, in my opinion, they're not of a different scale. They're just a different type.
One is more administrative and one is more coverage of program, correct?
I would agree to that, yes.
Okay. Now I am, because I'm not a lobbyist, I was not too directly involved. I was only sort of keeping, distance track of the processes that occurred leading to the NPDES statute, as well as the amendments to the Water Quality Act. Can I ask, at the time that NMED was interacting with the legislature in the attempt to get both of those acts passed, was there any discussion in terms of the funding for that program and how the state might envision that those programs would be funded?
So I was not, I participated in drafting statutes and putting together information. Ms. Lemon and Mr. Armstrong were the ones who represented the department for Senate Bill 21. So a lot of those discussions I cannot speak about. I can speak that there have been legislative appropriations to the Water Quality Management Fund. Now, how those were negotiated, I'm on the receiving end. I have not participated in those negotiations.
Do you know if those allocations or appropriations were specifically related to NMED seeking this rulemaking, or were they earlier and related to other things?
I do not know the specifics.
In your role as assisting with the development of this rulemaking and as well as the statutory, the efforts to get statutes passed for this program, did you consider whether it might make sense to first ensure that there is at least some funding available from the state legislature for example, the primacy program that's being sought under the NMPDES Act?
So financial questions like that are
Sorry, I think your counsel's about to make an objection.
I was about to make an objection. I believe this is outside of Ms. Lucas Kamat's testimony, and she's already stated that she's not aware of how the funding was negotiated during the legislative session.
That's fair, and I'll move on. I appreciate that objection. Ms. Lucas Kamat, Do you believe that one option this commission has is to essentially put a hold or some sort of pause on seeking primacy until the state and the NMED has an opportunity to ask the legislature for permission or for funding for that program?
I think Senate Bill 21 gave the statutory requirement for a program. And so whether or not the commission can ignore that statutory requirement is a legal question. I am not.
I appreciate that answer, and I'm not intending at least to ask you a legal opinion here, but if the commission decided that it wished to put a pause, since there's no deadline, I think we established through Dr. Fuad for the adoption of the MPDES primacy program, that doesn't necessarily mean it's not pursuing that program. It means that it's delaying the pursuit of that program until there might have been an opportunity or two in future legislative sessions to seek appropriation to partially at least fund this program, correct?
Objection to that question. I believe Ms. Lucas Kamat has just answered it.
Madam Hearing Officer, I'm not sure that she has answered that particular question, but I'm happy to get your thoughts if you think I'm overstepping.
So I think you should move on because I think she's already given you the best answer she has.
Okay, thank you. Am I correct that even if both aspects of the rule were to be adopted by the commission, there would be no specific, there would be nothing that the state NMED could do to affect the coverage of Clean Water Act coverage under the WOTUS concept?
Can you repeat the
Let me-
question? I heard a conflict, so I need.
Yeah, let me thank you. Let me try to ask a better question. Well, let's break it down. If New Mexico, if this commission were to adopt the state permitting program in order to pursue the urgency of protecting state surface waters, there's nothing that NMED could do under that program to change the scope of how WOTUS is determined at the federal level, including by the Supreme Court.
Correct.
Similarly, if the commission were to adopt the the NMPDES primacy component of today's rulemaking process, there would be nothing that NMED could do after receiving EPA primacy over that program to affect how WOTUS is conceived of in the scope of Clean Water Act coverage that's determined at the federal level, correct?
Correct.
Okay. Have there been complaints, to your knowledge, from the regulated community about how EPA has administered the NPDES program?
Complaints, no.
Was there more to your answer that you wanted to provide?
There have been comments about inspection frequencies, how compliance schedules are handled, but they haven't been complaints.
And so is it the case that that the regulated community has not complained about how EPA has administered the NPDES program over the 5 decades of EPA's administration of that program?
I've only been involved for 5 years, so I can say for 5 years, I have not heard complaints. I cannot speak to the previous decades.
Okay. And I understand that NMED may believe that there is some common sense to having primacy over the MPDES program while it's also pursuing a separate surface water permitting program that's being proposed here. I get that and I understand it. But would you agree with me that there's really no urgency to take over primacy of the MPDES program?
No urgency in the sense that there is not a loud upwelling from industry to take it over? No.
But I assume from implicit in your answer is that there is a desire, for example, of EPA to have NMED take over primacy of the 402 program.
Correct.
Okay. But even if this commission puts a pause on the MPDES primacy part of this two-part rulemaking, EPA is obligated to administer that program, the 402 program for New Mexico until primacy is obtained, correct?
Correct.
Okay. And would you consider it to be potentially a bridge too far to ask this commission to adopt an NMPDES program when the immediate effect of that, or fairly immediate effect of that, is for fees to go from zero to, in some cases, hundreds of thousands of dollars between application and annual fees?
The effect of the fees is not immediate. As I testified, we'd have to implement in phases. Fees will not be due until your MPDS permit expires and you're applying for an application. You're not going to pay annual fees until NMED is issuing the permit. You're not going to pay for an NMED application fee for us to issue the permit until your MPDS permit as written by EPA expires. And we assume the responsibility of writing it.
And sitting here today, Ms. Lucas Kamat, can you inform the commission which of the individual MPDES permits held by the regulated community in New Mexico expire by which dates?
I do not have that information in front of me. Out of the 95 permits, they all have 5-year terms. We have permits expiring once a month, once every few months. We have general permits expiring for about one a year on general permits. So I can't tell you which permits will expire when. That information is available. I just don't have it.
And I think inherent in that answer is the fact that I may not have been clear with my question. My question just related to individual permits, but your answer included both individual and general permits, correct?
Correct.
How many individual permits, MPDES permits, does EPA administer for the state of New Mexico?
95 right now.
95 individual permits.
Correct.
And many of those, they're quite varied between Los Alamos, perhaps at the most complex end, and perhaps some of the POTWs at the lower end.
Correct.
Okay. But the fees that would come into effect as permits are due to expire and new ones need to be applied for, those would apply to those holders of the individual permits.
Correct.
And those are individual permittees that, from your testimony, have not complained about how EPA has administered the program.
Correct.
So is it fair for me to conceive of the benefit from seeking primacy over the MPDES program as one that is conferred primarily on the state of New Mexico as opposed to individual MPDES permittees?
No, and it's because it's not just, the permits are not just going to, well, the permit fees are not just going to writing the permits. They also include compliance assistant, planned compliance assistance, depending how they end out. So working with permittees to keep them in compliance. But I would say all the discussion on fees, that was really outside of my testimony. And so that was reviewed by Ms. Lemon and Mr. Connolly.
And I missed my chance to ask them questions. Thank you for that. So let's focus, and this is for either or both of you. Let's focus on the proposal for this commission to adopt a surface water permitting program that includes both a point source and a dredge and fill permit aspect to it. Do you understand the framing of that so far?
Yes.
Okay. If the state, and I'll ask you first, Dr. Fawad, if the state adopts, if this commission adopts that surface water permitting program that includes both a point source and a dredge and fill permit aspect to it, would you agree with me that that program could function independently from New Mexico seeking and obtaining primacy from EPA over the Clean Water Act, either Section 402 or the 404?
Yes, as me and Ms. Lucas Mott said, that those are separate programs and they can.
And I think you may have already agreed with that concept in so many words, Ms. Lucas Kamat. Is that correct?
Yes.
Okay. This is a highly legalistic formulation of a question, but in combining two rules in one rulemaking, has NMED potentially bitten off more than it can chew?
We're here. So I don't think it's more than we can chew. We have capacity. We've provided testimony. We've provided oral testimony and answered questions.
That's a fair answer, and I think pursuant to your notion about making sure that there's an economy of scales, you've essentially achieved that purpose by pursuing both in one proceeding, correct?
Correct.
But you haven't obtained the staffing of 57 permit writers and others who would administer the programs, correct?
Correct. I also think Ms. Lemon spoke to this someday last week, that it's not 57 people all at once. We are slowly staffing up, and so as elements and components come on, we will continue to staff up.
But that ramping up, so to speak, would be a less steep ramp if you were to pursue these programs one at a time in sequence. Would you agree?
Actually, I wouldn't agree, because I think the skills we have to train people on are across all of the programs. And so I think ramping up both the NMPDS and the state direct discharge and the straight dredge and fill, again, it's a scale. If I've got if the Surface Water Quality Bureau has to hire 10 people, hire 10 people and train them now, as opposed to phasing it in.
And when in the opening statement, your counsel acknowledged the chair of this commission's observation back at the first time this program came up at the WQCC as being a very complex or very large process, right?
Yes.
And that would be less so if you were to take these things, as I would submit, more logically, one step at a time.
There are elements that go across all the sections. So just doing one for the state dredge and fill, it's the same work. Like anti-degradation is anti-degradation. Training someone how to do the public notice, training someone how to do the public comments, it's the same. So again, it's the economy of scale and scalability I keep talking about. It's easier to do it all at once.
And in terms of Dan Connolly's testimony, I think you were here for his testimony, correct?
Yes, I was here for his testimony.
And he testified that permit writing is a very complex undertaking and sometimes takes 3 years just to become an average permit writer. You remember that testimony?
I remember that testimony. It's also the same for inspectors and for what we do right now for one certification writers. It's not easy work that we do. We don't do easy work in the Surface Water Quality Bureau.
And Mr. Connolly also indicated that it's hard to retain permit writers, correct?
That was his statement, yes. But he also comes from a permit writing universe that is predominantly professional engineers. He spoke about they require professional engineers. We have purposely classified our positions as water resource professionals so that we can have a systematic endpoint. You know, sometimes I have an engineer like Dr. Fuad. Sometimes I'm a trained geologist, geophysicist. I have chemical engineers. I've had other environmental scientists. We've got a PhD in wetlands work. We have a broad range of professionals that work for us. We're not just engineers.
Thank you for that testimony. I'm going to turn now, Ms. Lucas Kamat, to the I guess what I would just characterize as the primary emphasis of your testimony, both direct and rebuttal, and that is the definitions in these programs. Am I correct that those definitions have evolved over the course of 3 or 4 different iterations? In other words, let me just lay out what I understand them to be. The initial petition for proposed rulemaking, and then in a first amended petition, there were changes made to those definitions. And then again in the second amended, which is now 79B, I believe.
A and B.
A and B, that they've changed again in that context, correct?
Correct.
And most of those changes have been in order to bring the definitions in line with the State Rules Act admonition that either the definition should be exactly as stated in the statute or should be cross-referenced to where those appear in for example, the NMPDES Act.
Correct. That is represented in Exhibit 79A and B.
And have you heard the testimony from some in the last couple of days that expressed a preference to have the definitions restated right in the rules rather than cross-referencing to the NMPDES Act, for example?
That testimony, yes.
Is it NMED's, do you know, is it NMED's intention to come out with a further iteration that heeds those preferences from the people? In other words, at the end of this proceeding, when we're doing close post-hearing submissions, will there be another iteration that now repeats the same definitions, or do you know?
It is my understanding that we're going to follow the recommendation of the State Records and Archive Center, and we're going to reference the definitions as found in both the Water Quality Act and the New Mexico Pollutant Discharge Elimination System Act.
So there's not going to be a sort of a one-shop, here's all the definitions that you need to know for the regulated community. There's going to be cross-references to the acts in one case, and also cross-references to section 20.6.4, where, for example, the state surface water standards are stated and includes a definition of surface waters, correct?
Objection. Ms. Lucas Kamat just answered how the department intends to address the definitions, and also that was a very complex question.
That's a fair observation. I appreciate that. Ms. Lucas Kamat, I think we heard early on in this proceeding that although it's the State Records Center's preference to either cross-reference the statute where definitions appear in the statute or restate them exactly as they appear in the statute, but that in some cases there were maybe some punctuation changes to definitions and the like. Do you recall that testimony?
I recall that testimony, yes.
Can you, sitting here today, and I'll understand if you can't, can you identify the definitions that are now in the latest 79A and 79B iterations of the rule that in some way, however small, change definitions that are otherwise stated in the Act?
In my oral testimony, I included the definitions that were part of my direct testimony that are going to reference what's in the Act. And let me get to it. Facility, general permit, pathogen, sludge, source in the Water Quality Act, and that's in 20.6.2A. Federal Act, National Pollutant Discharge Elimination System, New Mexico Pollutant Discharge Elimination System, and pollutant are in the New Mexico Pollutant Discharge Elimination System Act, which is 20.6.5. And then in 20.6.2 and 20.6.5, the definitions for general permit coverage, new source, and point source. Other definitions were included in Ms. Lemon's testimony, and I cannot speak to those.
Thank you for that. Dr. Fuad, I've got a couple questions for you related to the general permit process that you outlined. And am I correct that there's really two aspects to the general permit process? One, when it's a general permit under the Clean Water Act, and another if there's a general permit under the state surface water program?
Yes, correct.
And are they correlated, if you will? Are they the same if it's depending on if it's an NPDES related permit, general permit versus a state surface water permit?
So they're very similar. I identified a few differences. Some of those are timelines. And then, do you want me to go to that? There are some differences.
Okay, thank you. There are some differences, and I appreciated your testimony that. Would you agree with me that your testimony essentially responded to Ms. Khan's proposal to have public input process both at the time of issuance of the general permit as well as at the time individual regulated community people provide a notice of intent?
Yes.
And your recommendation is to only do the public input process at the stage of issuing the general permit before anybody has asked for coverage under that permit.
Yes, we are, or the rules propose that while the department issues a general permit, which is a permitting action, and the department will have a public notice, public comment, and the public can request a public hearing as well.
Okay, and am I correct that just looking at the NPDES side of the equation, or in this case, the NMPDES side of the equation, that a general permit, one who seeks coverage under a general permit would provide a notice of intent, and then within 15 days would have coverage unless there's some issue raised by the agency? Am I getting that correct?
Yes.
Because that's the way it happens at the federal level.
Yes.
But,
so I will add that in the federal level, there is no 15 days clause, at least that I know of. But in our proposed rules, the department will have 15 days to take a decision, either approve the authorization or request more information or deny the authorization.
and on the side of the equation that's the surface water permitting program, general permit, when one seeks coverage under, for example, just a general permit for construction or whatever it might be, the process there is that 14 or 15 days is provided, and then an additional 30 days for the agency to decide whether or not the person who submitted the NOI is entitled to coverage under that.
I'll have to look for it.
Madam Hearing Officer, while he's looking for that, could you let me know how much time we have left?
7 minutes.
Thank you. That's what I thought. I just was confirming. Okay.
So while looking, if you could point me out where the extra 30 days are, because I'm having difficulty finding, or
I am not going to be able to do that sitting here right now, but I will represent to you that I understand the proposal to be that once there is a determination made of administrative completeness, when one seeks coverage under a general permit on the state surface water permitting side, that triggers a 30-day period for the agency to conduct its technical review to determine whether or not that applicant is appropriately covered by that kind of permit, correct? Does that sound familiar?
I do not recall the extra 30 days, but if it could be there if you read it. I don't recall.
Well, maybe let me ask this, is that if there is an extra 30 days, is that necessary considering that that's not present on the federal and NMPDES side?
I cannot testify to that right now because, as I said, the federal general permit coverage and the state coverage are similar, quite similar, but still has a little nuances, some nuances to in between those two. So if there is a 30-day, which I'm not recalling right now, I cannot testify to the justification for that.
But Dr. Quad, it's NMED's proposal, is it not, that there's no need for a second round of public input after a general permit has been issued at the time when the regulated community or members of the regulated community seeks to submit an NOI seeking coverage under that program, correct?
Yes, that's my testimony.
And would it be fair to say that that's at least in part because the agency is fully capable of figuring out whether from the NOI and from its review and process to determine whether it's administratively complete, that the agency is fully capable of determining whether coverage is appropriate?
Yes, but if there's an extra 30 days, I'm not testifying to the capability within how many days, but the department is capable of.
Understood. That's fair enough. But the point is, both the request for an additional round of input at the time of the NOIs and the opportunity that Ms. Khan proposed to seek an appeal to this commission when authorization or coverage is determined to be appropriate by the agency. The basic rationale is that NMED is seeking for the general permit part of this process to be an efficient process that does not get hung up and tie up projects in the state of New Mexico because of first an opportunity for input, a second opportunity for input, and then an appeal to the commission, correct?
Yes, correct. That's my testimony, that this process of allowing public comments and public notice for the actual permitting action is more efficient than asking for requiring public comments for each individual NOIs.
Thank you. And I understand that part of the rationale that you provided in your testimony for not allowing an appeal to be taken when authorization is given under a general permit. I understand that part of that rationale is that there's no permit action at that time. It has already occurred when the general permit itself was issued, correct?
Yes.
One last question. If an NOI is submitted to the agency seeking coverage under general permit, and that request is denied, and a letter comes out saying, no, you don't qualify for this. Rather, you need to, if you're going to pursue this, you need an individual permit. That would be a permit action that the party who got the denial would have the opportunity to appeal to the commission, correct?
That would be a permit determination, and the subsequent processes of applying, getting an administrative complete application, including the fees, that will be a sort of a permitting action.
Okay, thank you again very much for your important testimony. That's all the questions I have.
Thank you, Mr. Boutier. Mr. Stomp, do you have questions of this panel? We will need to take a break in about 20 minutes.
Thank you, Madam Chair. Sorry, thank you, Madam Hearing Officer. I think I have a break in my questioning where it would work well, I think. Good morning, Ms. Lucas Kamat and Dr. Fuad. I appreciate your testimony today. My name is John Stomp, and I'm representing the Albuquerque-Bernalillo County Water Utility Authority. Well, I will call the Water Authority just because the name will take all my time up for the questions. So I'm going to ask Ms. Lucas Kamat some questions with respect to reasonable potential, and that's covered in section 20.6.2. 0.2310, 20.6.2.2314, and section 20.6.5.407 NMAC. Ms. Lucas Kamat, are you familiar with those sections?
Yes, I am.
Could you explain what is a reasonable potential analysis?
A reasonable potential analysis is an analytical model run based on both the effluent quality of a facility or proposed facility and the receiving stream quality that receives the effluent from the facility, and then the water quality standards. And so it's essentially a mixing cell model. It's for the reasonable potential of the facility to cause an exceedance in, this is where exceedance you don't want to do, will cause you to cause in the receiving stream higher concentrations of pollutants than what the water quality standards are. So you take the effluent water quality, you take the effluent volume, which is the design flow, and then you look at the receiving streams critical low flow quality, and you look at the water quality standards that are in 20.6.4, and you essentially do the math, wave your hands, do the math. It's beautiful if you're a math person. And you see if there's a potential for the discharge to cause water quality standards to be exceeded.
So in your testimony, did you say that the purpose of a reasonable potential alternate analysis would be to determine whether that discharge or proposed discharge would violate water quality standards of the stream or potentially tribal water quality standards?
I think I said that, but let me double check.
Okay, thank you.
I am only seeing it in my rebuttal, and I mentioned in my rebuttal that the reasonable potential analysis is an implementation guidance and tool.
But you are familiar with what the definition of a reasonable potential analysis is?
I am.
And could a reasonable potential analysis lead to a new or a more stringent water quality standard for an NMPDS permit?
Yes.
Could a new or more stringent water quality standard limit require the design and construction of new treatment processes at a wastewater treatment plant?
Theoretically, yes.
So for a large discharger like the Water Authority, could a new or more stringent water quality limit require potentially millions or even hundreds of millions of dollars for implementation of new treatment processes?
For a large discharger in any large community, yes.
So would you agree that a reasonable potential analysis could have significant economic consequences for the Water Authority or other wastewater dischargers?
Reasonable potential analysis, if it finds there's a more limited effluent limit to be required, could require additional treatment or planning.
Is there a definition of what reasonable potential or reasonable potential analysis is in the regulations?
There is not, as I said in my rebuttal, reasonable potential analysis is an implementation. And so it is not used anywhere in the rules. That would be something in the implementation part of the program, similar to anti-degradation, where it would be part of our water quality management plan.
So there's because there's no definition of reasonable potential in the regulations, there's the factors that go into reasonable potential, and you kind of talked about those at the beginning where you look at the flow and the various water qualities. They're also not defined in the regulations, are they not?
The low flow is defined in 20.6.4 as a 4Q3. And harmonic mean is defined, I'm sorry, 20.6.4. Harmonic mean and low flow characteristics are defined in 20.6.4. Ambient is not defined. Ambient water quality is not defined. But by the same token, effluent water quality is not defined. And that's the basis of all NMPDS and the proposed state permits.
But even those small definitions that you spoke about, there's no process or factors that just tell a particular permittee how you would actually use those factors in calculating a reasonable potential analysis, correct?
Currently, EPA, we don't have delegation yet, so we do not have a procedure or an implementation policy for that. That all lies with EPA currently.
Okay, so I guess my question was a yes or no question. Are the factors that go into a reasonable potential analysis, they're not defined because there's no definition of reasonable potential analysis, is that correct?
Some of the factors are defined, the 4Q3 and harmonic mean. The other factors are not.
Were you present when Mr. Jonas Armstrong testified for NMED?
I was.
And Mr. Jonas Armstrong testified that having clear definitions in the regulations would help provide certainty to the regulated community. Do you agree with that statement?
I do. I would also say that definitions have to be used in the rules. And so right now, reasonable potential analysis is not used, so it doesn't warrant a definition.
Well, in the rules in section 20.6.5.407, under the secretary's final action of a permit, there is a section that says that the secretary could use a reasonable potential analysis as a means of adding new or more stringent water quality standards in a permit. Does it not say that?
I'm getting there, 1 second. 20.6.5407, what's the letter?
I believe it's C or D. I apologize. Let me look. I'm sorry, it's A,
Okay.
paragraph A.
It is there. Anti-degradation or reasonable potential analysis.
So it is part of the secretarial's discretion and authority to be able to evaluate that. Yet there's no actual definition in the regulations to give any permittee any idea of what that actually means.
Correct.
So given the potentially significant impact that a reasonable potential analysis could have on the water authority and other permittees, would the department entertain the addition of a definition of reasonable potential in the regulations?
I think we would.
Are you familiar with the water authority's proposed definition?
I have read it. I don't recall it off the top of my head.
Is that something that you would consider also in adding to this to the regulations in that section?
I would consider looking at the water authority's definition and making changes as the department felt appropriate.
Thank you. Can you tell me, in your rebuttal testimony, you stated that reasonable potential analysis is an implementation guidance and tool. Is that correct?
Yes, I did.
You also stated that it will undergo a public comment period and approval by the WQCC. Is that correct?
That is correct. That is part our water quality management plan undergoes.
Thank you very much. Can you tell me what the timeline is for the public comment period and the approval by the WQCC for that proposed reasonable potential analysis guidance and tool? Sorry, that was a long question.
I cannot speak to the WQCC's timeline. I can speak to what our process would be. We would need to develop similar to the anti-degradation, we'd need to develop the implementation policy, which would lay out the calculations that are done, the data that needs to be collected, the data quality objectives, the QA/QC required for that data. I cannot give you a timeline right now of when we would submit that document because we need to have rules first in order to move forward. I would anticipate it being sometime in a year or two, because we also need to put, that would be not the anti-degradation. The reasonable potential analysis could be part of the standard operating procedures and policies that are part of our submission to the EPA. And so I would say in 1 or 2 years, most things when we take them to the commission, like the water quality, WQMP, I'm blanking on the full names, our TMDLs, our waste load allocations, those typically go out to public notice, 30 or 60 days. They go to the commission 30 or 60 days after that, and then it's up to the commission and their schedules of when they're approved.
And were you here for Ms. Lemon's testimony?
I was.
I believe she said that the application for delegation of authority from EPA was going to be submitted sometime in early 2027, some 6, 8, 9, 10 months from now. So when would this guidance document and tool, you said that's going to have to be complete before NMED makes application to EPA?
It may be complete. We may just reference it.
But it may not be complete if it has to be there has to be a public comment period and a WQCC hearing on that matter. Correct. Prior to the application being submitted. Okay. Madam Hearing Officer, I have questions on a different topic. I could begin that, or I could stop now and pick that up at 1 o'clock or after public comment period.
Thank you for saying so. I think this is a great time to take a lunch break. We need to be back at 1 for public comment.
We should take.
Thank you.
Let's come back from the lunch break, please. we have Mr. Chair joining us. We are back after a lunch break. So we'll be returning the room into a planetarium. We're on day 6 of the hearing in WQCC 25-74 relating to surface water quality permitting programs. We have reached the time that we accept public comment each day. So I will call on folks who raise their hand in the room first, and then I'll go to the platform. So, sir, I saw your hand first in the okay, sure. The cranberry colored shirt. And then the black shirt. Yeah, great. And then, ma'am, yes, glasses. Terrific. Come on up. Just a few things about public comment. I will ask you to spell your first and last name because we're making a transcript. I will ask you pursuant to commission rules to swear or affirm that you will tell the truth. I'll ask you to keep your comments to 3 minutes. If you have more to say, please write it out in an email and send it to Pamela Jones, the commission administrator. Her information is on the WQCC webpage. So, sir, if you would spell your first and last name.
Sure. My name is Adam Ringia. Adam, A-D-A-M, Ringia, R-I-N-G-I-A, N as in Nancy.
Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Thank you very much. Good afternoon, Madam Hearing Officer, Mr. Chair, members of the Commission. Again, my name is Adam Ringia. I am the Deputy Chief of Operations for the Pueblo of Laguna. I also serve as their Acting Environmental and Natural Resources Director and was the Natural Resources Director when the Pueblo of Laguna created its treatment as a state and water quality standards. I'm going to focus specifically on that issue. I understand that there's some discussion about what tribal water quality standards are and what we feel it should be. We would prefer that those standards are standards established by the governing body pursuant to Indian, national, tribal, or Pueblo law. And the reason for that is there are many, but the largest one is the onerous burden that going and getting a treatment as a state and then subsequent water quality standards is. And very briefly, I want to walk you through that process because I went through it and it takes some time. So in order to get to those last 2 steps, the treatment as a state and then the water quality standards, a Pueblo or tribe has to first enter into agreement with EPA for a general assistance program. They may do that for some years until they develop the capacity to develop a water quality program. That may go on into eternity without the tribe choosing to develop treatment as a state. In Laguna's case, we started our GAP program, our General Assistance Program, back in the 90s. Didn't get a water quality program until the early 2000s. Maintained that until 2016 when we applied for treatment as a state and didn't get our water quality standards approved until 2017. This allows for many different gaps to happen where there will be challenges of whose standards apply. And you know, the Pueblos, just like the state, have to have standards that meet or exceed the federal EPA standards. So in addition to that very brief stepwise process, you can stop at any point. So there are tribes out there that have applied for treatment as a state in, say, 2014, still do not have have water quality standards in 2026. So there's again, there are these stops after each phase of the process, and we want to make sure that we don't have that issue. The EPA under Senate Bill 21 no longer has jurisdiction over the water quality standards. That's the state. So why would we require a federal process in order to get something approved by the state? Obviously, I could go into painful detail if you really want me to on a variety of treatment of estate and water quality standard issues, but it takes a lot of legal work, it takes a lot of jurisdictional work, it takes a lot of financial resources, and especially with the current federal administration's cramping up the DOI and EPA, removing all kinds of staff, I expect those timelines to only increase, increasing the potential challenges that the state would face in applying one standard or another.
Thank you, Mr. Ringia. If you would please spell your first and last name. Thank you.
You need
button
to press the
green?
green.
The button needs to be green here.
Oh, okay, there you go.
There you go.
Okay, first name Harry, Harry, middle initial A, last name Antonio, Antonio, and suffix Jr., Junior.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead.
And besides my whole name, I'm also the governor of the Pueblo of Laguna. And here we go. Good afternoon, Madam Hearing Officer, Mr. Chair, members of the commission. On behalf of the Pueblo Laguna, I would like to share my comments on the proposed amendment 20.6.2 NMAC and the proposed new rule 20.6.5 NMAC. Pueblo of Laguna has protected the waters that flow through our lands for generations. Our Environmental and Natural Resources Department monitors surface water quality to ensure that this precious resource is safe from pollution. We safeguard the water to protect our communities while this use of water for ceremonial and everyday purposes, and to protect the wildlife and natural inhabitants on our lands. The legislature recognized our role as water protectors when it enacted Senate Bill 21. This requires the New Mexico Environmental Department to deny any permit for a surface water discharge into state waters if that discharge would cause or contribute to water contaminant levels in excess of a downstream state or tribal water quality standard. Including the term tribal water quality standards reflects the fact that there are multiple sovereign governments in New Mexico. The legislature clearly saw Pueblos as co-equal sovereigns with the state of New Mexico by requiring the department to deny permits for surface water discharges that would violate the tribal standards, regardless of whether the discharge will meet the state standard.
Mr. Antonio, I'm sorry to interrupt you. Would you slow down a little? We're trying to catch every word.
Okay, well, you said 3 minutes, so I'm trying to get through here. So, okay, alrighty. But what is a water quality standard? The Pueblo of Laguna asked this commission to define this term as standards established by the governing body pursuant to Indian National, Tribal, or Pueblo law. This definition recognizes that tribal governments are vested with the authority to protect the water in the way of their own choosing. It helps to resolve future conflicts, but because it creates a unified system for protecting water as it flows through the state and tribal lands. And it is practical because the state is responsible for approving or denying permits, and the Pueblo should only be responsible for establishing standards according to tribal law and sharing those standards with the state permitting agency. However, some parties would like the commission to include qualifying language that tribal quality waters must be applied in tribal water quality programs. This language is flawed. It creates an opportunity for organizations to pollute into our waters on the argument that the Pueblo has not sufficiently applied their standards or that the Pueblos does not have a sufficient water quality program. This language is also contrary to the design of SB 21. Polluting entities will not be applying for permits with tribal agencies, but with the state agencies. In effect, the state agency would apply tribal water quality standards by approving or denying permits. Requiring that Pueblos create water quality programs before their standards are enforceable would impose an unnecessary burden that would not add any functional value to the state program. The plain language of SB 21 requires cooperation between the Pueblos and the state of New Mexico as co-equal sovereign governments. This commission should give life to SB 21 in a way that respects tribal sovereignty. And so we ask you to define tribal water quality standards as standards established by the governing body pursuant to Indian, national, tribal, or Pueblo law. And thank you. Just to elaborate a little bit more, I was told that a tribal member should be a part of this commission, and I agree with that. So I'll mention that in my notes back to to the person you described earlier that we can write comments back to. But I also appreciate the fact that Governor Grisham has opened up a lot for tribal communities in this state over her last 2 terms, and we greatly appreciate that. And so you guys should be no different. You folks on the commission should be no different. You represent the state in that fact. And so I would appreciate it, what we just testified on and what all the tribal communities are commenting on, that to be taken seriously. We work to collaborate and in consultation as well. And so we're on that belief that the state is willing to work with us, and they have. And you guys, many of the state legislators in the House and the Senate have done their portion. And you are many members of that the legislature. So I gratefully thank you and appreciative that you guys have paid attention to your duty as we have. And so I'm just asking on behalf of the Pueblo of Laguna that this commission move forward with what we just testified to. Thank you very much.
Thank you, Mr. Antonio. Let's see. Ma'am, there you are. If you would spell your first and last name, please.
TAMMILAMBERT.
Thank you. Do you swear or affirm to tell the truth?
I so swear.
Please go ahead.
Good morning, hearing officer, members of the commission. My name is Tammy Lambert. I'm the Government Affairs Director, the head of the legal office at the Pueblo of Laguna. I wanted to bring my comments primarily around the issue of tribal sovereignty and the question of whether or not tribes should be required to have treatment as a state provisions in their water quality standards. I'd like to bring your attention to a 10th Circuit case, a federal 10th Circuit case, City of Albuquerque versus Browner, where the Pueblo of Isleta had a 10th Circuit case, City of Albuquerque v. Browner. In that case, the Pueblo of Isleta had a treatment as a state with the EPA and wanted to impose water quality standards that were higher than the EPA recommended standards so that the Pueblo could protect their water for ceremonial use. The federal court, the 10th Circuit, upheld the Pueblo's stringent standards. And they held that even though the EPA was responsible for applying the tribe's water quality standards, the Pueblo of Isleta had the sovereign authority to determine the water quality standards that the EPA would apply. The reason why that's important is that if this commission imposes a treatment as a state requirement on tribal sovereignty, it may run into legal challenge as being opposed to the Browner case already held by the 10th Circuit. The other important thing to recognize is that the tribal water quality standard is the sovereign authority of the tribe. It is the Pueblo's sovereign authority to issue those standards. The state does not have regulatory authority to impose laws or standards on the tribe. By imposing a requirement for treatment as a state to be a precondition for honoring water quality standards, the state exceeds its lawful authority by imposing a rule condition on the tribes. So not only is it onerous, costly, and time-consuming, and very difficult for tribes to have a treatment as a state, that does not mean that tribes don't have the right to set their own water quality standards according to their own rules, customs, and traditions. And the state does not have the rulemaking authority to require the laws of the tribe to be in a particular way. Sovereign government to government authority and collaboration means that we collaborate and honor the rules of each. We are not having the authority, the tribes would not have the authority to make our own law, to make the state do a particular thing. And similarly, as a sovereign, the state would not have that authority. The last thing I'd like to add before I leave is where person is defined as a tribe in the proposed rules. I would like to respectfully remind the commission that the state does not have regulatory authority. So where person is subject to regulations, that does not apply to the tribes and pueblos. Thank you for listening to my comments.
Thank you, Ms. Lambert. Let's see. Yes, go ahead. Come on up. If you would spell your first and last name.
First name Arlette, Arleth. Last name Perez, Perec.
Do you swear or affirm to tell the truth?
Oh, what was, I'm sorry?
Do you swear or affirm to tell the truth? Thank you. Go ahead.
Good afternoon, Commission. My name is Arlette Perez, and I live here. I live in Albuquerque. I'm a college student studying astrophysics, and I'm grateful for the opportunity to speak with you today. As someone who hopes to build a future in New Mexico, I believe there is no resource more valuable than water. Water is the foundation of life. It supports our families, our farms, our wildlife, and our economy, and every community across the state. Once it's polluted, it can take generations to recover. Growing up, I spent so much free time outdoors. Some of my happiest memories are camping with my family, exploring the Rio Grande, and spending weekends in Jemez. Those places taught me to appreciate the beauty of New Mexico and to understand that our natural resources are not guaranteed. They depend on the choices we make today. As a science student, I've learned that every ecosystem is connected. Small streams, wetlands, and groundwater may seem insignificant on their own, but together they sustain wildlife, agriculture, and the people who call New Mexico home. When one part of the system is damaged, the effects spread far beyond a single location. I also dream of raising a family here one day. I want my future children to experience the same rivers, lakes, and landscapes that I shaped my childhood. I want them to fish, swim, hike, and camp without worrying about contaminated water or disappearing ecosystems. We have a responsibility to leave them something better, not something diminished. That's why I ask you to carefully consider the impact that large-scale developments, including data centers, could have in our state's limited water resources. While technology and ecosystem growth are important, they should never come at the expense of clean water that every New Mexican depends on. Progress and environmental must go hand in hand. I encourage you to adopt strong protections for waterways, require responsible water management, hold developers accountable, and ensure that local communities and tribal nations have meaningful voice in these decisions. Protecting water is not anti-growth, or it's pro-health, pro-economy, and pro-future. When people think about New Mexico, they often think of desert. But what makes this place truly special is how precious every river, spring, and wetland is. In a dry state like ours, every drop matters. The decisions you make today will shape the New Mexico that my generation and the generation after us inherits. I hope that the future will include clean rivers, healthy ecosystems, and enough water for families, farmers, wildlife, recreation, and responsible innovation like that. Thank you for your time, your service, and considering my comments.
Thank you, Ms. Paris.
Thank you.
See. Sir? Just spell your first and last name.
Mario Garcia, Mario Garcia.
Thank you. Do you swear or affirm to tell the truth?
I do.
Go ahead.
Good afternoon, Chair and Commission. My name is Mario Garcia, and I work in the local hospitality industry here in New Mexico. Thank you for the opportunity to be here today and provide comment on this important rule-making process. Growing up in a single-parent household after losing my dad when I was young, I watched my mother work incredibly hard to provide for us. That experience taught me early on that water is the literal lifeblood of everything we do. Without it, our families, our service economy, and our daily survival completely collapse. Working in hospitality, I see how our state's beauty brings the world to our doorstep, but my true connection to this land comes from the time I spend with my family. Whenever I get a day off, we love to hang out by our local lakes and walk through the Rio Grande Bosque. Exploring those shaded trails along the river is how we stay connected, remember my dad, and recharge. But with climate change contributing to hotter temperatures, prolonged drought, and shrinking water resources, places like these cannot be taken for granted. This is why this rulemaking process is so important to help protect the waters that sustain our communities, our traditions, and the places we cherish. Another huge part of our life here is visiting the local farmers markets. My family relies on them for fresh, healthy food, and I love seeing the incredible variety our state produces, from fresh green chili and squash to sweet corn and local fruits. But none of those goodies would exist without clean, abundant water. If our water sources are compromised, our local farmers cannot grow their crops or markets empty out, and we lose access to the very things that feed and sustain our communities. My generation wants to build our lives and careers right here, but we cannot do that if we inherit ruined ecosystems and dried out farmlands. I, u- I urge the Commission to adopt strong, comprehensive, clear, and enforceable rules that fully protect New Mexico's waters from existing and future pollution. We need these strict protective boundaries for every stream, wetland, and seasonal waterway in New Mexico to keep our water systems viable. Sorry. We must stop pollution before it hits our watersheds and require developers to find cleaner alternatives. Our working moms, local vendors, and young workers are counting on you. Please pass the strongest possible water regulations today so we can continue to enjoy the natural bounty of our state. Thank you for your time, attention, and consideration of my comments today.
Thank you, Mr. Garcia. Sir with the collar. If you would spell your first and last name. Make it green.
I'm colorblind, but I can see. John, John, and Wester, Wester.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank you very much for hearing me today. A couple of years ago put out a pastoral letter on nuclear disarmament, which part of it talked about the danger to radiation in our waters and contamination. And I'm about, actually, coincidentally, in a few weeks to put another pastoral on the sacredness of water and the importance of water in our lives. And so I urge the Commission to adopt strong, comprehensive, clear, and enforceable rules that fully implement SB 21 to fully protect our waters from existing and future pollution. SB 21 provides an historic opportunity for New Mexico to establish a strong state permitting system to safeguard rivers, streams, wetlands, and other essential surface waters. However, as you know, the law's success depends on its effective implementation. As climate change intensifies, drought and water scarcity, New Mexico cannot afford weak protections that jeopardize our limited water resources. Weak rules would leave vulnerable waters, communities, and future generations at risk for years to come. The need for action is urgent. Every river in New Mexico was included on the 2024 Most Endangered Rivers list. And so I urge the Commission to adopt rules that, first of all, protect the full breadth of New Mexico's surface waters, including rivers, streams, wetlands, and the smaller tributaries and drainages that sustain them. Also, to be at least as protective as lost federal protections, including incorporating the 404(b)(1) guidelines to ensure that impacts are avoided, minimized, and compensated for. Also, to protect tribal waters to the fullest extent possible, and to ensure robust public participation so New Mexicans have a meaningful voice in decisions affecting their water. And finally, protect wildlife by requiring meaningful engagement with the New Mexico Department of Wildlife. New Mexicans deserve clean, safe, and reliable water. I urge the Commission to act accordingly to pass strong, clean water protections that ensure a healthy and safe future. Thank you very much.
There. Other hands on this side of the room? No. Hands on this side of the room. Oh, I think I see Commissioner Garcia. Come on up, and the young man next to you as well. If you would spell your first and last name.
Paula Garcia.
Do you swear or affirm to tell the truth?
Yes.
Go ahead.
Good afternoon, Chair and members of the Commission. My name is Paula Garcia, and I'm Executive Director of the New Mexico Acequia Association. I belong to Acequia del Alto del Norte in Mora County. For over 30 years, and in my current position, I've worked with hundreds of acequias across the state, working to protect water rights and clean water. I've heard stories and testimonials about the importance of clean water by irrigators, farmers, and ranchers who depend on the acequias for their way of life and their livelihood. Our relationship with the water is very intimate and direct. Our children play in the rivers and acequias. It's a rite of passage to clean acequias every spring with our neighbors, as has been done for generations before us. Our cultural traditions call upon us to bless ourselves on Dia de San Juan with the waters that flow through our rivers. The water in our acequias recharges our aquifers, feeds our animals, and waters our crops. The water that flows in our rivers ends up in our gardens, irrigating heritage crops and market crops that sustain our communities. The water that flows in our rivers, the surface water that will be the subject of this rule, comes into direct contact with the food that we eat. Therefore, that makes it important not only for our communities, but also anyone who eats the food that we grow, from farmers markets across the state and grocery stores, and anyone who's concerned with robust local food systems. NMAC for over 3 decades has engaged in policy advocacy and providing technical assistance for acequias. I'm here to speak in support of the proposed rule to create a surface water quality program. There are approximately 700 acequias in 23 counties across the state, and each of them depend on surface water to grow crops that are a vital part of our economy, culture, and heritage. For acequias, we say el agua es vida, water is life, and we call it a don divino, or a divine gift. And in that way, these sacred waters sustain our communities and our livelihood and our way of life. This new program will be vital to protecting the surface waters, which we rely upon. We are asking for this commission to enact a rule that will do the following: protect water in our rivers to ensure our acequias flow with clean water, prevent pollution now and in the future by enacting effective and enforceable regulations, protect the full breadth of New Mexico surface waters, including rivers and streams, wetlands, and the small tributaries that sustain them, be at least protective as the lost federal protections, including considerations for agriculture. In that regard, we are advocating that agricultural exemptions be clear so that surface waters are protected while also ensuring that acequias are not overburdened with regulations. We would like to be a close collaborator with NMAC to strike that right balance. Also, we hope that the rule will ensure robust public participation so that New Mexicans have a meaningful voice in decisions affecting their water. This permitting process is a vital part of ensuring that communities have agency in protecting the water that ensures their well-being for generations to come. Thank you for your consideration.
Thank you, Ms. Garcia. Just spell your first and last name, please.
Vincent, Vincent, Montoya, Montoya.
Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Good afternoon, Mr. Chair and members of Commission. My name is Vincent Montoya. I am a tribal member of Santa Clara Pueblo, where I live with my family. I am a young Pueblo man who enjoys spending time outdoors, hunting, fishing, and an upcoming youth fly fishing guide. Growing up connected to the land has shown me how important water is to every part of our lives. Water is not only essential for drinking and farming, but it also supports the rivers, streams, plants, and animals that our communities depend on. As a Native American, water has a deeper meaning because it is tied to our culture, traditions, and way of life. Many of our teaching emphasize the importance of respecting and caring for the natural world, and protecting water is a major part of that responsibility. Clean, healthy waterways allow me to fish, spend time with my family outdoors, and stay connected to the traditions that have been passed down through generations. As a part of the next generation, I want to see our rivers, streams protected so that our future Pueblo youth can enjoy the same opportunities and connection to the land. Protecting clean water today helps ensure a healthy future for our people, our wildlife, and generations that will come after us. Because water is so important to us all, I urge the Commission to adopt strong and enforceable rules that prevent pollution in our rivers by enacting effective and enforceable regulations, protect all of our surface waters, including rivers, streams, wetlands, and smaller tributaries that sustain our culture, animals, and people. Ensure robust public participation so people have a meaningful voice. Uphold tribal sovereignty by including the recommendations of tribes. And finally, the New Mexico Department of Wildlife should play a meaningful role in this permitting process. As a young Pueblo man, we all deserve clean, safe, and reliable water. I urge the Commission to act accordingly to pass strong, clean water protections that ensure a healthy and safe future. Thank you.
Thank you, Mr. Montoya. Anyone else in the room before I go to the platform? All right. On the platform.
Yes, Madam Hearing Officer, I have 5 hands raised on the platform. And I'd like to start off with Kay. Kay, if you could unmute yourself, please.
Hi, my name is Kay Bunga.
Hello. Would you spell your first and last name, please?
Sure, my first name is actually Viengkeo, Viengkeo, and my last name is Bunga, Bounkea.
All right. Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead.
All right. Good afternoon, Chair and members of the Commission. My name is Kay Bunga. I was born and raised in New Mexico and have been deeply invested in this community my entire life, including having served as a state representative. I speak before you not in any official capacity, but as a New Mexican and a proud mother. Recently, while driving over Paseo del Norte in Albuquerque to take my 7-year-old daughter to camp, the Rio Grande was completely dry. My daughter asked me, if the water is gone, what will happen to the trees and the fish? What happens to us? Much of my daughter's childhood has been spent walking between the cottonwoods and the bosque, skipping rocks in the river, and running along the acequias. When the acequias are filled, our joy is replenished with them, because we know soon the animals will return, the community will bless the water, and our neighbors will get to water their crops. But this happens less and less, as you all know. What water we do have must be protected. Climate change is here, and it is real. Our children and theirs are counting on us to safeguard what we all need: air, water, and land. New Mexico has already shown incredible leadership in creating its own surface water permitting program, and we must continue leading by adopting strong regulations that protect these same waters from pollution. New Mexico's water is too valuable to be protected by weak rules. Without strong protections, our waters, communities, and future generations will be at risk for years to come. I respectfully urge the Commission to adopt robust, clear, comprehensive, and enforceable rules that fully safeguard New Mexico's waters. What my daughter and all children inherently understand is that everything is interconnected. If our water is in crisis, so are we. Thank you.
Thank you very much.
Thank you. Next, Stephen. Stephen, if you can unmute yourself, please.
Hi, Stephen Glass, spelled
Hello.
Hi. My name is spelled Steven, first name Glass, Glass, last name.
Thank you. Do you swear or affirm to tell the truth, you former WQCC commissioner?
I do, Madam Hearing Officer.
Thank you. Go ahead.
And Mr. Chair and members of the Commission, having represented local governments on the WQCC for 10 years, I recognize the challenge you face in crafting rules for surface water permitting while trying to balance the priorities and concerns expressed by the many parties to this petition. Nonetheless, your work here holds crucial significance for the future of New Mexico water resources. I've previously submitted written comments, and I'm here today primarily to reiterate that the success of SB 21 depends upon the adoption of strong, clear, and enforceable rules to protect all surface waters of the state. The loss of protections resulting from the recent rollback of the definition for waters of the U.S. makes the effort ever much more important. With that said, I'm also aware that the necessary permitting fees needed to administrate the program will place a financial burden on water utilities and the clients they serve. So some recent testimony by Daniel Shuren with the Albuquerque-Bernalillo County Water Utility Authority offered some ideas to mitigate that burden, and I recommend considering her comments carefully. Thank you for the opportunity to make public comment today, and I wish you the very best in this process.
Thank you, Mr. Glass.
Thank you. Next, we'll invite Anita to unmute yourself. Anita.
Say it again.
Anita.
Hello, greetings. Yes, my name is Anita, and I'm grateful for this public opinion period.
Would you spell your first and last name,
yes,
please?
sure. And my first name is Anita, Anita. My last name is Amstutz, Amstutz.
Do you swear or affirm to tell the truth?
I affirm to tell the truth.
Let's go ahead.
Yes, so I am here along with all the prior commenters to ask and urge the Commission to adopt strong, comprehensive, clear, enforceable rules and implement SB 21, as well as incorporating 404B guidelines to ensure that impacts are avoided, minimized, and compensated for. I live in northern New Mexico, and as a northern New Mexico inhabitant, I've continued to see how the unpredictable climate and lack of precipitation is affecting our acequias, as it is through the whole state, diminishing snowpacks and looming industrial projects that are going to be water guzzling. I was a beekeeper for over a decade, and it became too difficult at some point to keep bees because of the unpredictable climate and the increasingly difficulty of bees finding surface water or clean surface water, or just surface water, period. And so you can imagine how farmers feel who provide the crops or the landscape that need our bees to pollinate. In closing, I just want to make a comment that actually speaks to the process and system of this public testimony. It's curious to me. It feels a little backwards that there's a process where it's incumbent upon the goodwill of the public to continually show up and protect and speak out for the protection of our waters, rather than a dedicated body of rules that has been continually in place that public officials or appointed officials will defend and represent and do the right thing. And I note being at many of these meetings that there are hours and hours of collective public wisdom and heartfelt testimony by ordinary workers, farmers, retirees, Pueblo residents, nonprofit workers, moms, dads, just people who show up with common sense about water, and also highly educated professionals who have a long experience of research in this and experience in this state. But what I've observed is that the public seems to be on trial, called back over and over and over to defend our water, air, and soil. And the dial seems to move in very little to rein in those industries or those who have the privilege of using any of our natural resources for the common good. And so it is curious that the average workers are called back day after day after day to defend our public water, because we all know from what we've heard that water is life. So I just hope that someday maybe the tables will be reversed with clear policies and protections that remain in place that are upheld by the state, the public officials, and all who are appointed. And so anyone who does business in New Mexico knows that there's a gold standard and laws by which they must protect our land, air, and water. And if there's not compliance, it is incumbent upon them to be on the stand, industrial CEOs, stockholders, boardrooms, and that the public is only here to keep those.
Ms. Amstutz, you froze right there. Well, her time had come to an end. Thank you, Ms. Amstutz, for your comment.
Thank you. Next, Andres, if you could please unmute yourself.
Can you all hear me just fine?
Yes, would you spell your first and last name, please?
Yeah, Andres Esparza, Andres. Last name Esparza, Esparza.
And do you swear or affirm to tell the truth?
Absolutely. Yes.
Thank you. Go ahead.
Good morning, Chair and Commissioners. My name is Andres Esparza, and I'm here today on behalf of the Pew Charitable Trust, a fact-based, nonpartisan nonprofit, to speak about water in the state of New Mexico. As others have said before me, water is the foundation of life. It sustains communities, farms and ranches, wildlife, the outdoor economy, and cultural traditions that stretch back generations. From acequias in northern New Mexico to wetlands, streams, and rivers across the state, water connects everything. And in a state as dry as New Mexico's, every waterway matters. That is why New Mexico's new surface water permitting program is so important. This rulemaking represents an opportunity to ensure that all of New Mexico's surface waters receive meaningful protection and that local economies continue to benefit from outdoor recreation brought about by clean water. That is why to adequately protect New Mexico's waters, the program should include protections that are at least as strong as those that previously existed under the Federal Clean Water Act. For decades, those protections provided a workable framework that supported economic growth, agriculture, infrastructure development, and healthy waterways. They should serve as the minimum standard for New Mexico's program, not the maximum. In particular, the state should incorporate into the program the federal 404B guidelines to governing dredge and fill activities. Those requirements establish a common sense approach. First, avoid impacts where possible, then minimize impacts that cannot be avoided, and finally, provide compensation for any remaining harm. Avoidance must remain the foundation of the program. Before a permit is issued, applicants should clearly define the purpose of their project and demonstrate that they have selected the least damaging practical alternative. Damage to wetlands and waterways should not be treated as inevitable when less harmful options exist. When impacts cannot be avoided, mitigation requirements must be strong enough to prevent the continued loss of aquatic resources. A minimum 2-to-1 mitigation ratio is an important safeguard because restored or created wetlands often do not fully replace the functions and values of those that are lost. Finally, the Commission should reject efforts to carve out or exclude certain types of waters from the program. Small tributaries, ephemeral streams, wetlands, and drainages are essential parts of larger watershed systems. They support water quality, reduce flooding, provide wildlife habitat, and help sustain the rivers and streams that New Mexicans rely on every day. The decisions being made in this rulemaking will shape the future of New Mexico's waters for generations. On behalf of the Pew Charitable Trust, I urge the Commission to adopt strong, science-based protections that safeguard all of New Mexico's waters and ensure they remain healthy for future generations. Thank you all so much for your time. I really appreciate the work you all are doing.
Thank you, Mr. Esparza.
Thank you. Next, we'll call on Allison. Allison, if you could please unmute yourself.
Ms. Civic, there you are.
Yes.
And would you spell your first and second name, please?
Yes, Allison, Alllyson, Civic, Siwik.
Do you swear or affirm to tell the truth?
I do.
Oh, please go ahead.
Great. Good afternoon, Madam Hearing Officer, Mr. Chair, and members of the Commission. I'm Allison Civic, Executive Director of the Silver City-based nonprofit Gila Resources Information Project, or GRIP for short. Thank you for the opportunity to provide comment today. For nearly 30 years, we've been involved in the regulatory oversight of hard rock mines in New Mexico. We also participated as a party in the rulemaking proceeding before the WQCC on the copper rule. GRIP also serves on the steering committee and is a member of New Mexico Mining Watch, a statewide coalition working with communities across New Mexico to ensure mining decisions protect water, community health, and the places we call home. First, I'd like to thank the New Mexico State Legislature for passing Senate Bill 21 and the New Mexico Environment Department for the proposed rules for a surface water permitting program. The vast majority of our waters here in New Mexico have lost federal Clean Water Act protections. Due to the U.S. Supreme Court decisions in 2001 and 2006, which was well before the Sackett decision, the waters in the Mimbres Basin here in southwest New Mexico lost federal clean water protections. Hard rock mining is consistently reported by EPA as the nation's #1 toxic polluter. The Chino, Cobre, and Tyrone mines all have surface water discharges to the Mimbres Basin. We need strong implementation rules to restore protections to Mimbres Basin waters and protect all the state's waters. I fully support the Commission ensuring that all of New Mexico's waters are protected from discharges. GRIP strongly disagrees with the Natural Resource Partners' proposed changes to the rule that would create exemptions for mine operators from surface water permitting for activities that are already permitted under the copper rule and that have groundwater discharge permits. This is ill-advised for the following reasons. The copper rule regulates groundwater discharges, not surface water discharges. So for instance, surface water percolation through a waste rock or leach stockpile are only regulated under the copper rule because of their potential for impacts to groundwater quality only. Moreover, the NMAC Groundwater Quality Bureau has no mechanism under the copper rule to enforce regulatory control of discharges to surface water because the copper rule regulates groundwater discharges, not surface water discharges. So the copper rule was not designed to protect surface water from mining, and therefore copper mines should not be exempt from provisions of the surface water permitting program. In addition, we need strong rules that require appropriate mitigation of impacts to aquatic resources. Over the past 200 years, New Mexico has lost, it's an estimated loss of over half of its historic wetland acreage. We can't afford to continue to lose surface waters that are important for community drinking water supply, agriculture, wildlife, and ecosystems. Therefore, we encourage the WQCC to set a strong mitigation ratio of 2-to-1. And NMAC should also develop and adopt detailed mitigation guidance that includes requirements for comprehensive mitigation plans. Finally, we are extremely concerned that the proposed rules do not allow public engagement or public comment on general permit coverage. The majority, in fact, almost all of surface water discharges under the state program will likely be regulated under general permits, yet there's no way for the public to comment on proposed discharges under general permits in the draft rule. Surface water discharges to the Mimbres Basin from the Chino, Cobre, and Tyrone mines are likely to be regulated through a state general permit. These discharges could cause significant impacts to receiving waters, and the public should have an opportunity for review and comment. So I urge the Commission to adopt a 15-day comment period on the general permit coverage requests. Thank you for considering my input on the proposed surface water permitting rules, and thank you for all you're doing for the state of New Mexico.
Thank you, Ms. Civic.
Thank you. Lastly, I have Ava on the platform. Ava, if you could please unmute yourself.
Ms. Curtis?
Hi, my name is Ava Curtis. That's going to be spelled A-V-A, last name Curtis, C-U-R-T-I-S.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank you. I'm just commenting on behalf of myself today, urging the Commission to adopt strong, comprehensive, clear, and enforceable rules that fully implement SB 21 to protect New Mexico's water from existing and future pollution. SB 21 provides a historic opportunity for New Mexico to establish a strong state permitting system to safeguard our rivers, streams, tributaries, seasonal waterways, and all other essential surface waters. However, that law's success depends on effective implementation. Water is very critical to the state. Where I live in Albuquerque, the Rio Grande River has recently dried, which is very early. And this place is such an incredible ecosystem. It's a great place for recreation, and it supports a really big diversity of animals. One of my favorite places to enjoy the river is at the Rio Grande Nature Center, where you can just see all that biodiversity. There's hundreds of species of birds, many small mammals, and lizards, and just so much life in that area. This water is also so vital for the local agriculture taking place in Albuquerque. Even in a city, we see urban agriculture thriving. We see farms in the South Valley relying on the water. And personally, I spend time working in a small community garden in the downtown neighborhood that provides fresh food for low-income and rent-subsidized neighbors. And all of this relies on our fresh water that's being protected by these rules. As climate change intensifies, drought and water scarcity, New Mexico cannot afford weak protections that jeopardize our limited water resources. The need for action is urgent. Every river in New Mexico was included in the 2024 Most Endangered Rivers list. So we urge the Commission to adopt rules that protect all of New Mexico's water, including rivers, streams, wetlands, and small tributaries and drainages, and establish requirements that are at least as protective as lost federal requirements. The historic clean water protections outlined in the Federal Clean Water Act, which are not applying, we need something at least as strong as that. And we also need to protect our tribal waters to the fullest extent possible, and permits should be denied if they could cause or contribute to pollution that exceeds downstream tribal water quality standards for both individual and general permits. NMED's definition of tribal water quality standards must be adopted and not weakened. And we must protect wildlife by requiring meaningful engagement with the New Mexico Department of Wildlife. For a rule that could dramatically impact at-risk wetlands and streamside habitat, requesting the Department of Wildlife's expertise is both common sense and essential to long-term protections and habitat health. New Mexicans deserve clean, safe, and reliable water, and I urge the Commission to act accordingly to pass strong water protections that ensure a healthy and safe future. Thank you for your time.
Thank you, Ms. Curtis. Anyone else in the room or on the platform? The next public comment session will be at 1 p.m. tomorrow. Now we'll return to the technical case. The third department panel would resume your places at the table. Mr. Stump is going to the examiner's seat. Excuse me. Just let me know when you're ready. Yes, all right. Go ahead, Mr. Stump.
Thank you, Madam Hearing Officer, and thank you, Ms. Lucas Kamat and Dr. Fuad, I'm sorry, for your testimony earlier today. And I'm going to ask some questions about compliance schedules, and those are covered under sections 20.6.2.7C8 and 20.6.2.2307 and 20.6.5407B1C NMAC. Ms. Kamat, could you explain what a compliance schedule is?
Yes, I can. So a compliance schedule is just gonna read what I wrote. It's a permitting, compliance, or enforcement implementation item, and it is defined. Okay, let me get it. I have it open, I just need to find it. It's a timeline within a permit that gives a facility a specific set period to meet new or more stringent water quality based limits.
Would you agree that it would be like a schedule that you would give to a permittee that would outline the steps necessary to implement a new water quality standard or a more stringent water quality standard?
Yes.
And for the water authority, could that include changes to its pretreatment program?
For any facility, a pretreatment program could have a compliance schedule, yes.
And in that pretreatment program, could it also include establishing new local limits for industry that discharge into the water authority system and the required public notice provisions that it would be necessary to implement those new local limits?
Pretreatment programs is a different part of NPDES than effluent limits. Can you rephrase that question or re-ask that question, please?
Yes, I'm very sorry. It was like a very long question. So for the water authority, I think we would say that, would you agree that the first step in implementing a new or more stringent water quality standard would be to evaluate people that are discharging, industry that's actually discharging into the water authority system under a pretreatment permit?
Not all water quality standards may be reflected in a pre-treatment program for any discharger. So I would say that the first step when there is a new effluent limit is to do a sewer shed survey or investigate your dischargers to see if they may be contributing to that effluent. So it could be part of a pretreatment program. It could be outside of the pretreatment program.
That's a very good point. Thank you. Would the Water Authority or other permittees also be required in a compliance schedule to implement new pretreatment standards? I'm sorry, to implement new processes at their wastewater plant?
A discharger would need to determine how to meet a new effluent standard that might be met through working with indirect dischargers, your industrial dischargers. It might be met by upgrading a facility. It might be met by implementing new procedures or optimizing. NMED does not dictate what you have to do to meet that new effluent standard. We just say you have to. And so sometimes that's done with, a combination of what I'd mentioned before.
That's true. And I guess the point I was trying to ask is just the timeline that it takes to look at these various components. Would you agree that it takes a lot of time to gather data and to figure out if a newer or more stringent water quality standard, where's that, particular constituent coming from? What's the quantity of it, and how would you remove it before you would get it to the stream system?
Correct. That does take time, that analysis.
In terms of a compliance schedule, do you have any thoughts about what the potential phases of a compliance schedule might be?
That's a hypothetical too broad for me to answer because it's very much specific on the treatment works, how the treatment, like what processes you use, what the limit is, and what technology is available. So I can't really answer that on such a broad hypothetical.
Okay, well, I'll try to straighten it out. If the Water Authority had to build a new treatment process, they would need to get funding for it, would they not?
Any utility typically needs funding when they are building a new treatment plan or treatment process, yes.
And they would have to do the design and get the permits necessary to construct it. Would that be true?
Correct.
And then they would have to actually construct the facility. Is that not true?
If a new facility is required, correct.
And then they would have to actually practice and start it up and make sure that it's actually working the way it's supposed to before they start discharging.
Correct. There's an optimization time.
So there's a lot of various steps that would be necessary to implement a new treatment process.
Correct.
So for a lot of wastewater treatment plants in New Mexico, would you agree that securing the necessary funding for design and construction of projects like this would take an extended period of time and would likely be very difficult for many wastewater treatment entities in New Mexico?
I am not, that's not covered in my testimony. I don't have anything about the economics of various water treatment plants or municipalities.
Do you agree that a permittee could be making every reasonable or diligent effort to meet the timeline in a compliance schedule, but still may need more time than one permit period to complete?
Yes.
Would interim deadlines in a compliance schedule potentially provide more flexibility for permittees because it may take more than one permit period to achieve compliance?
Interim deadlines are typical in compliance schedules.
Okay, if a compliance schedule is necessary, can you tell me how the department is planning on developing those compliance schedules?
The department plans on developing the compliance schedules the way EPA currently develops the compliance schedules, which is discussion with a facility on what the new effluent limits are. And compliance schedules are not just permitting, they're also on compliance and enforcement. And so I'm going to sort of talk across the two, determining where the effluent exceedances are or where the operation and maintenance issues are, talking with the permittee about what the effluent limits are going to be or what the enforcement compliance actions are going to be. We anticipate having a back and forth. EPA has been doing this most recently with what they call their enhanced compliance schedules, where there's a discussion of what the facility sees they can do. One of the things is with the compliance schedule, in a permit, it has to be a 5-year time frame, and that's per the Clean Water Act. So one of the items would be developing interim standards. So we have had some compliance schedules recently. Do a sewer shed, identify where you think the inputs are. Work with an engineer to develop the appropriate engineering response to those inputs. Do a rate study to identify your funding sources to pay for the rate study. Work with the Southwest Environmental Law Center at UNM to identify other funding sources. Include time for securing budget, include time for build out, realizing that build out may be incremental, and then figure out time for optimization to make sure that things actually work. And sometimes in there, like there can be pollutant minimization plans. Sometimes you may not need to build out a new facility. You may just need optimization of your current one, or optimization of your current facility may get you one step closer to compliance.
So it sounds to me like you're planning on coordinating with the permittees as you're going along and developing a compliance schedule.
Correct.
I think that's a great idea. In terms of the steps that you just kind of went through in terms of working with them, looking at the potential issues, do you believe that the current definition that you've provided allows for that flexibility and has the language that'd be necessary for a regulated entity like the Water Authority to feel confident that the things that you just spoke about, which would be very important, are in the definition?
I think the definition meets the purposes, yes.
Are you familiar with the Water Authority's proposed amendments to the compliance schedule section in sections 20.6.2.7 C8 and 20.6.2 2307 and 20.6.5 407 B1C?
Yes.
But the department didn't accept any of those proposed revisions, did they?
We did not. Part of this definition is pre-treatment specific, and compliance schedules are not limited to facilities that have pre-treatment programs, and so that would be prescriptive.
Well, do you believe that the words that you said before, I think providing flexibility to permittees is exactly what you were talking about. And that's what the Water Authority was proposing in its language. So is there other language that you could add to the existing definition that would give more certainty to the regulated community in terms of providing that flexibility, which is going to be incredibly important for Water Authority and small treatment plants in New Mexico?
I think that, like any definitions, the department is open to considering proposed language that would add flexibility. Yes.
Thank you. In your rebuttal testimony, you stated that compliance schedules are permitting, compliance, and enforcement implementation guidance. Is that correct?
Yes, that is correct.
And you also stated that those documents will undergo a public comment period and approval by the WQCC. Is that correct?
What do you mean by those documents?
The compliance plan, implementation procedure, and guidance documents that you referenced in your rebuttal testimony.
Compliance plan procedures would be part of our water quality management plan. So yes, the water quality management plan currently undergoes commission approval and a public comment period.
And will those documents be required to be done and complete prior to NMED makes application to the EPA for delegation of authority?
No, not necessarily.
Why not? Why would they not be necessary?
Because the water quality management plan is a standalone document from the application.
Isn't the implementation of compliance schedules a necessary part of implementing delegation of authority from EPA?
Can you repeat the question, please?
Isn't the ability to put compliance schedules into NMPDS permits an important part of the delegation of authority from EPA?
To my knowledge, no. Best of my knowledge.
Okay. That's all I have for you. I have one question or a couple of questions for Dr. Fuad, please. If a new wastewater treatment plant is proposed that will require an NMPDS discharge permit, are there any provisions in the regulations that allow NMED to provide feedback during the design phase on potential proposed permit conditions?
So potential permit conditions depend on information provided to the department and subsequent analysis. So the permit, if the new plant is not in existence, there is no data available, then there are ways to use data to come to those conclusions, which then goes into the permit.
And what's the timeline for submission of an application for a new NMPDS discharge permit?
So for a permit from submission to getting a final action, provided that there is no hearing involved, public hearing involved, it's 180 days.
The proposed rule states that it's 180 days from an acceptance of an administratively complete permit. EPA currently encourages brand new applicants to submit 180 days in advance. The department, because of anti-degradation requirements, typically suggests people have pre-meetings with us a year in advance. It can take a year for a facility to have all the data for an anti-degradation review.
So during that pre-treatment or pre-meeting, would it be possible for the department to provide some feedback on what they anticipate the regulatory framework might look like for a new wastewater discharge?
The regulatory framework is established in 20.6.4 with the water quality standards.
Yes.
And so in that sense, that is already provided.
I guess I'm not trying to be hard here. I'm trying to think if a new wastewater treatment plant was going to discharge to the river and you have to design and construct that, you have to know what you're designing for. So you wouldn't submit an application to discharge without knowing what your designs could be. So it would be really important for us to meet with you so you could tell us what you think the design criteria might have to be able to comply with the permit that we're going to ask you for after the construction's done and begins operation.
Correct. And by the same sense, we can't tell you what your limitations are going to be unless we have the design information and models of your effluent characteristics.
Okay. But I'm looking at the stream standards. We're going to design the plant to meet certain stream standards. So we're just looking for, because it's very confusing on how an applicant would actually know what they're going to design to without some help from the department in terms of what those standards might be.
Right. And what we normally tell people is we'll help them identify their receiving stream. Like that's part of, we tell people meet with us early. We will identify the receiving stream. We can identify the low flow characteristics. And with the receiving stream, we can say, here's the most stringent requirements would be to meet the water quality standards of the receiving stream at the end of the pipe.
Right. Thank you, Madam Hearing Officer and members of the commission. I don't have any more questions.
Thank you very much, Mr. Stump. Ms. Taylor?
Good afternoon, everyone. This is just a couple of questions for Ms. Lucas Kamat. Were you here when Ms. Lemon testified about a consideration of the department to create a general permit for small POTWs?
I was.
Can you just tell me what the status of development of that general permit is?
We have not started on that general permit.
Do you have any idea when that draft general permit may be available for public comment?
After adaptation of the rules and probably in the next year or so, like.
All right, thank you. That's all the questions I have.
Thank you, Ms. Taylor. Mr. Parkamenko, do you have questions of this panel?
I do not. Thank you very much.
Thank you very much. Mr. Brooks?
Good afternoon, Ms. Lucas Kamat. My name is Caleb Brooks. I represent Middle Rio Grande Conservancy District. Do you understand who I am and whom I represent?
Yes, I do.
Do you have a copy of NMAC Rebuttal Exhibit 2, your original rebuttal testimony in front of you?
Yes, I do.
I want to direct your attention to page 4 of that document. You just let me know when you get there.
I am there.
So at the bottom of the page, second to last paragraph, you testify, the department is committed to deleting all instances of composed entirely from the agricultural return flow exemptions and definitions of point source in both 20.6.2 and 20.6.5 NMAC. First of all, did I read that correctly?
Yes, you did.
Is that still NMED's position?
As Ms. Lemon testified, the composed entirely is in the Water Quality Act. And so I defer to her testimony on this.
So if I understand you correctly, you're basically withdrawing that piece of testimony from your rebuttal?
Correct.
Do you have any understanding at all as to why NMED decided to retain the composed entirely language in Exhibit 79A and 79B?
It has to do with it being included in the Water Quality Act.
Okay. So it's purely a legal justification, not a policy justification that you could testify to?
Correct.
Do you still think it's sound policy to continue to define composed entirely in a way that's consistent with federal practice?
I think that it is defined in the Water Quality Act.
Okay. So in this rebuttal testimony, you referenced discussions with Environmental Protection Agency. What do you recall about those discussions?
Can you give me a specific line item or location?
Yeah, that same paragraph I just asked you about, the lead-in to the sentence I quoted a few moments ago.
We had multiple discussions with the EPA, the Environmental Protection Agency, to make sure that the proposed 20.6.5 NMPDS rules would meet the requirements that EPA has to approve a program.
Okay, and just from context, I understand your testimony to be that EPA advised you that that composed entirely language was not necessary for the state to gain primacy. Is that correct?
The discussions were primarily legal, and so I know it was one of the discussion points. I do not remember the specific details.
Were you present when Ms. Lemon testified?
I was.
And I understand from her testimony and the testimony of other NMED witnesses that NMED does not intend to change the treatment of agricultural drains that are currently exempt from permitting requirements. Is that basically right, to your knowledge?
Defer to Ms. Lemon's testimony, yes.
Okay. Would applying a composed entirely qualifier to the return flow exception and definition of point source be inconsistent with federal practice as you understand it?
I do not know.
Okay. Do you personally support maintaining federal practice with respect to the agricultural return flow exception?
I support incorporating federal exemptions as they are written and any requirements in the Water Quality Act or the New Mexico Pollutant Discharge Elimination System Act.
Have you reviewed MRGCD's proposed definition of composed entirely in Mr. Kasuga's rebuttal testimony?
I have.
Do you have a position as to whether that definition ought to be recommended to this commission?
I do not.
Okay. No further questions. Thank you, ma'am.
Thank you, Mr. Brooks. Ms. Richards.
Good afternoon.
Good afternoon.
I'm Dory Richards, and I represent the National Nuclear Security Administration. I have some questions. I'm hoping to not be duplicative, but I missed a few things in the earlier testimony today, so I will have to go back just a wee bit. First, I'm wondering, since you both are working on the process and the implementation, could you tell me whether an ephemeral reach that has been demonstrated at hearing before this commission to not support aquatic resources, whether it would still require a point source discharge permit?
It may, and it depends on what the other designated uses of that ephemeral reach are. You specifically said it doesn't support aquatic resources. I would have to look at what the other designated uses of that reach were to determine what designated uses and related water quality standards may need to be met.
So we could effectively have to revisit some of those issues the commission may have already heard. Is that right?
The commission voted on aquatic resources that those are not the only designated uses. So if they didn't determine the other designated uses, they're not revisiting them. They're just adding additional determinations.
But it could require another proceeding in front of the commission. Is that correct?
That is correct.
In the process, in this overall process, who would determine whether a discharge is a point source discharge?
Can you repeat the question, please?
Sure. I can bring you back to some of the testimony earlier from, I think, Ms. Lemon on her panel. There was discussion about whether a natural bottom is a point source discharge, if you line it, if you have it going through a pipe. So I'm trying to find out who and at what part of the process would the determination be made that this is a point source discharge requiring a permit.
So as Bureau Chief Lemon suggested, that we are now proposing a period for making that determination if permit will be required. In that sense, when the department gets a request For that determination, the department will then determine if it's a point source and if it requires a discharge permit.
So essentially, you don't know if you need a permit. You have to apply for it anyway and wait to find out whether or not it meets the definition of point source discharge. Is that what you're saying?
So as you just said that there is a definition of point source discharge. I'm not sure where in the rules that will, whoever is requesting that determination, they will have to know if they meet that definition. If they don't understand, then they can file that request regardless.
So the applicant can look at the reg and say, I don't think it's a point source discharge. The bottom of it isn't lined. I think I'm good. And then the department can come back. So they don't submit an application. And the department can come back and issue a violation saying, oh, we think that is a point source discharge.
So not knowing the law is not a defense as far as I understand. And it's not a legal opinion. It's how I understand regulations. And if there is a definition, and if you're looking at the definition, I understand that you have some reason to look at the definition because you are trying to determine yourself if you meet it or not. If you're not sure, then you apply for the determination with the department. That's how I understand it.
Well, I don't think the question was about knowing the law or not knowing the law. The question is more about who and when is it determined this is a point source discharge within the interpretation of the department. And if you can't answer that, that's fine.
I can't answer that who in the department and when will make that determination.
But it's your understanding that if you don't know, you just got to submit an application and pay a bunch of fees and wait for the department to decide.
That's not correct. So how we have proposed is you apply for the determination, request for the determination, the department will make a determination. And if you do need a permit, you'll have to submit a full application. And after the department determines if the application is administratively complete, we will let the applicant or potential permittee know how much fee they will have to pay. And then after they pay the fee, the application process kicks in.
So where in the process does it outline this preliminary submission of a request for a determination on whether or not it's a point source discharge?
We currently don't have it in the submitted rule. It was Bureau Chief Lemon who discussed this in her testimony.
So that's just a gap in the rule as it's currently proposed.
I wouldn't say it's a gap. It's an improvement to the rule as it proposed.
But it's not in the rule currently, correct?
Yes, what I said.
Do you know, I'm just trying to figure this one out, the wildfire response, what type of permit would be necessary for wildfire response?
You're talking in the dredge and fill?
Yes, please.
We did not testify to the dredge and fill.
And there, to the best of your knowledge, is there any need for a permit for wildfire response in the NMIPD's portion of the program?
There is a possible wildfire retardant general permit.
So let me ask this. If there was a wildfire and there was helicopter drops, spraying of water, whatever we need to do to control it, and that water, not retardant, flows into an arroyo, would you need to go back and get a point source discharge?
So the plan is it would, general permits, oftentimes you get them before it happens. The plan would be to work with the Forest Service on the permit coverage well before fire season started. That was a permit that the federal government had been working on for a while, and that would be how we would do it.
What's the nexus with Forest Service? Because this may not be necessarily a Forest Service activity.
It's retardant drops. And so
I'm not talking about retardant drops, just let's say just water, trying to figure out just water. And what I'm getting back to kind of point source discharge. You have a helicopter, big drop of water trying to put out a small fire. The water flows into an arroyo and there's some erosion and what have you. So I'm trying to find out, would a permit have been required? Would it be required after the fact? And is that a point source discharge?
that has a lot of hypotheticals at this point. Like, I would need to sit down and work it all out. So I cannot answer your question at this point.
What about a prescribed burn? Let's say Kirtland Air Force Base is going to have a prescribed burn to reduce fuels. They have a prescribed burn, starts to get out of control. They use plain water, and that water flows into a arroyo. Again, is a permit needed? Is it a discharge?
I cannot answer that hypothetical at this point.
And can you advise, if you know offhand, where in the rule I might be able to find some of those answers?
I cannot.
I'm wondering about the 5-year permit requirement for the NMAC style permits. Why choose 5 years instead of 7 years or 10 years? Because it seems to me perhaps reducing resource and resource load if you extend it out a couple of years.
That's the EPA requirement.
So you're taking over the program, you can't extend it beyond 5 years?
You cannot extend it beyond 5 years, even though we're going for delegation, the Clean Water Act and the EPA rules still apply and EPA still has oversight.
That's true for the 20.6.5, but not for 20.6.2. Is that correct?
That is correct.
And are you going for longer periods in the state waters of the state?
So we are not going for it, but we have the provision to go for a longer term up to 10 years.
And is that discretionary based on each individual permit?
It's not a discretion, it would be need-based.
Need-based. And what are the factors that would support that need-based decision?
So we cannot answer that question right now. It will have to depend on what kind of general permit we're proposing, because it will just depend on that, what kind of discharges we're looking at.
So that's just on general permits, not individual source permits?
I am not sure, but if I recall, it's for both. I could be wrong.
And do you know what section of the rule addresses the factors for that need-based determination?
No, because we haven't decided which general permit we are proposing in the rules. It will be when we propose, or the secretary proposes the general permits, it will be there. I cannot, and I do not know.
So it's not in the rules, but you might put it in the permit anyway.
We have the provision in the rule, so.
The provision is actually in the Water Quality Act, 74-6-5.
And it outlines the factors, because I thought the factors would be part of the rulemaking. I mean, I think the statute may allow for it, but it wouldn't outline the individual factors. That's something that the department would normally do in its rulemaking, but I didn't see that.
I do not see anything in the statute.
Thank you. Ms. Lucas-Kamat, earlier in your testimony, you talked about a phased-in approach over the course of several years for different permit categories. Do you recall that?
Yes.
Okay. I'm sorry, I missed part of it. I wrote down year 1, 2, 3, 4, 5. I only got number 4. So year 1, what would you be proposing?
Well, so that was an example. That's
Okay.
not a definitive. So the 5 components are individual permits, general permits, federal facilities, which includes both individual and general permits, pretreatment, and biosolids. And so we could do the very simple year 1, we do all individual permits. Year 2, we do all general permits. Year 3, we do pretreatment. Year 4, we do federal facilities. Year 5, we do biosolids. We have the flexibility to determine as the state, like, we're going to do all the individual permits for wastewater treatment plants and pretreatment in year 1. And then in year 2, we could say, oh, we're going to do all the stormwater general permits. In year 3, we might say federal facilities and municipal stormwater. And so that, that was not this is how we're going to do it. It was meant to be an example of we can choose how we phase what permits in.
So at this point, that phased approach isn't identified anywhere. It's just something you'd implement in the future.
Correct.
And then, and that would still take into account existing permits. So example, if you had an EPA permit under 402 and you're in year 1 and your phased approach, you're starting federal facility in year 2, that would be postponed until the end of the permit cycle.
Correct.
And would that apply to both the 20.6.2 program and the 20.6.5, the phased in approach year 1, 2, 3, 4, 5?
So since it's specific, it's the specific NPDES elements. So it's specific to 20.6.5, that phased approach to those 5 elements. That being said, for 20.6.2, we are not going to issue 20 general permits at once. So the permits will be phased in.
So I think it sounds to me like the kind of the implementation concepts are still in flux for the department. Is that fair to say?
The timing of the implementation.
Timing and which types, when you do it, how you do it. Would anything prohibit the department from first just moving forward on the 20.6.5 program while it continues to flesh out and rework 20.6.2?
Senate Bill 21 included the need for regulations in NPDES and the state discharge program.
Correct, but nothing would prohibit you from starting with a program that has some bookends, like the federal program has some bookends, Clean Water Act and implementation, folks are familiar with. Nothing would prohibit you from starting with that, continuing to work on 20.6.2 for some of the gaps and issues folks has right during the hearing, and maybe move in a year or 2, does it? I'm just saying nothing prohibits that, correct?
As I said before, there's an economy of scale. It takes just as much work to do. Actually, it takes more work to do them separately than it does do together.
And so that's actually such a good phase in for me, because that's where we're going next, is that discussion of economy of scale. Let me ask you this. Do you have any estimate as to the number of permits you would be initiating under 20.6.5 absent initiation of 20.6.2 at the same time?
So there are 95 individual permits, NPDES individual permits. So over the implementation of the NMPDES program, we would have 95 individual permits, with the caveat that there may be new discharges coming online that would fall under the NPDES and the NMPDES program.
And so too, however, out of those 95 permits, some of them are still in valid time periods. So you wouldn't address all 95 in year 1, would you?
We would not take all 95 all at once, no.
And can you tell me how many additional permits you are now expecting if you were to phase in 20.6.2 at the same time as 20.6.5.
I believe Ms. Lemon included that in her testimony. I believe Ms. Lemon included that in her testimony.
Well, since it sounds like you'll be implementing a lot of this in your division, I think, if I understood everyone's division correctly, I'm wondering from your perspective, I don't recall her having that type of number.
I do not have the state permitting program numbers. I know it was included in Mr. Connolly's estimates for fees.
And when we're talking about economy of scale, we're considering, well, if we phase in 20.6.5, we have 95, but when we add in 20.6.2, we have another 100. And some of those efforts will duplicate. That's economy of scale. And so I'm trying to understand the economy of scale discussion if you don't know which kind of work functions, et cetera, are duplicative.
So it's not just general permits, it's also individual permits. It's also standing up all the SOPs for the various, like the standard operating procedures for the various requirements. So as Mr. Stomp had talked about, reasonable potential, it's the same amount of work to stand it up. You gave an example of 100 state permits as it is for the 95 NPDS permits. It's the same economy of scale to create an anti-degradation tool for a small number of state permits as a large number of state permits. It's the same amount of work to stand up the inspector credentialing process in the state program versus the NPDS program. And so it's easier if we can do it all at once and address both programs at once, as opposed to focus on, oh, we're going to do this for NPDES. And then when we start looking at the state permitting program, see that, oh, we didn't think about this consideration.
Ms. Richards, I'm sorry to interrupt. Would you find a good stopping place for a short break?
If you want to stop now, probably the best idea.
Let's take 10 minutes. Back at 2:55. Let's see. All righty. The commissioner's making their way to their chair. Y'all are ready? Ms. Richards.
Thank you. Okay, we were talking about kind of economies of scale and the types of things going into establishing both 20.6.5 and 20.6.2 when we broke. I think in follow-up to those questions, I would assume, and I would find it surprising if this wasn't the case, that if you were to start with 20.6.5 program, you would need less permit writers than you would if you started with both 20.6.5 and 20.6.2. Do you think that's correct?
I do not think that's correct.
So your testimony is that you would need the very same number of permit writers to move forward implementing just 20.6.5 that you would if you also added in 20.6.2 right off the bat.
Right off the bat, we will need fewer permit writers than when we have a fully implemented program on both NMPDS and the state permitting program. But I think we will need very similar amounts to implement just NMPDS or just the state program, because we will need to be generating general permits. We will need to be generating individual permits, permit writers. Part of the permit writing process is doing the reasonable potential analysis, doing anti degradation, and that work, a lot of it's what I keep coming to with the economies of scale. You're going to need the same number of people to implement all these procedures, whether we do just one program or both programs.
Okay, so you're talking about now implementing the procedures, but if you have only, you testified that about 95 permits would be covered under the 402 primacy. And we talked about that being substantially less based on the ones you'd have to start working immediately.
We would have 95 individual permits. We would have 6 or more general permits being phased in under MPDS. We would have 5 pre-treatment cities. We would have to implement the database to take in applications to accept discharge monitoring reports, to assume biosolids reports. All of that work, it's the same amount of work to set up a database for 1 permit as it is for 5 permits. It's the same amount of work to set up a database to receive discharge monitoring reports for 3 individual permits as it is for 20 individual permits. So this idea that it is a heavy lift to set up either program, and a lot of the heavy lift is shared across the programs. And so it's more efficient to set up both programs at once.
So it sounds to me like the desire to set both programs up at the same time is to generate fees to help offset all the kind of infrastructure SOP aspects versus actually drafting permits and monitoring permits.
The impetus to set up both programs at once, Senate Bill 21 was one bill with both programs in it. That is why we are trying to set up both programs at once.
But again, the Senate bill does not require that, correct?
The Senate bill was one bill to set up 2 programs.
So is your answer that it's a correct statement that Senate Bill 21 does not require you to set them both up at the very same time?
Objection. This has been asked and answered.
It has been, Ms. Richards, and in fact, she covered these same questions with Mr. Boutier earlier today.
And thank you, hearing officer. That's where I was driving to. Mr. Boutier asked questions about the steep hiring ramp, and I still don't think we've gotten a clear answer about, do we need 20 permit writers off the bat versus 57? And that's why I'm trying to get some more granularity in the answers.
Okay, and she already said this morning in response to Mr. Boutier's questions that it would not be 57 all at once.
Okay, let me move on to some questions about, in your direct testimony around page 12, you separate out federal facilities, the permit program, versus, I think, everybody else, every other category. Do you see that?
Yes, federal facilities is one of the EPA designated program elements of an MPDS program.
Does the EPA program break out federal facilities from municipal and industrial point source programs?
The EPA requirements for an MPDS compliant program separates federal facilities out. The 5 components of an MPDS program as defined by EPA are individual permits, general permits, federal facilities, biosolids, and pretreatment.
Are you aware as to whether or not the EPA program breaks out federal facilities differently?
The EPA program has the same permitting staff working on federal facilities, much like New Mexico would. I do not know how the EPA breaks out their programs internally. They have one permitting section. They have compliance and enforcement in 2 or 3 sections.
So in your testimony, you state that federal facilities are treated as a separate component of the NMIPD's program, primarily to ensure compliance with the Water Quality Act while navigating complexities. and unique operational activities. So I wanted to ask you about some of these complexities and unique operational activities. Can you tell me what those factors include?
What do you mean by factors?
I'm trying to understand essentially what is so unique about a federal facility that it couldn't be treated similarly to an industrial facility.
And I included in my written direct, they often conduct unique activities such as military training and operations, nuclear production, large-scale construction that requires specialized pollution prevention plans, and unique stormwater management strategies.
And are you aware that neither Sandia National Laboratories or Los Alamos National Laboratories conduct military training?
Yes, I am.
And can the state regulate nuclear production activity?
That is outside the scope of my testimony.
It's in your testimony that that's one of the considerations. If it's a consideration, I'm wondering whether the state can regulate nuclear production activity.
The facilities can conduct the nuclear production. The state can regulate the discharges from that nuclear production.
All
So
discharges?
if it's a discharge to a surface water, there is an exemption for materials under there is an exemption in the rule that relates to some nuclear waste materials, but the state can regulate discharges from from facilities. The EPA currently has an industrial discharge permit at Lanel. There are general permits at both Lanel and Sandia.
So are you familiar with the types of permits that Sandia National Laboratories has?
Yes, I am.
And can you identify what those are?
The NMPDS permits?
Yes, please.
They have a multi-sector general permit that has various sectors. I know one is for Sector R, Sector K, which are radionuclide producing. Sandia also occasionally has construction general permits because those are construction specific. They may or may not be active at any time. Sandia National and actually Sandia National Laboratories and INTES both hold the MSGP. Sandia National Laboratories and INTES have both held CGPs at the same time. Sandia National Laboratories and INTES also hold a current MS4 permit.
So, well, I can tell you currently they do have an MSGP and an MS4 and a construction general permit. Those are the three that they have. So let me ask you about construction, because the statement here is that it's unique and more complicated in part because of large scale construction. How do you define large scale construction?
So by large scale construction, I mean that the national lab, specifically Sandia at times, has had construction related to some of their testing sites. They've had construction related to large office buildings. And I would also say, like, I was not specifically calling out the national laboratories, which is why I include military operations. A lot of our military bases have large scale construction sites. This was not meant specific to Lanel or specific to Sandia.
I'm just trying to explore the different criteria because it does seem to me that a lot of these things happen in private industry outside of federal facilities too. So let me ask you this. Would you consider the Facebook Meta facility to be a large scale construction facility?
Yes, and it was required to have a construction general permit.
Are you familiar with small modular nuclear reactor construction programs?
I'm familiar, yes.
And would you consider that to be part of nuclear production?
That's electric generation. I don't consider that nuclear production.
So given that industrial activities and entities have these very same functions, I'm still puzzled about how and why we're distinguishing federal facilities as its own program.
we're distinguishing federal facilities as its own program because the Clean Water Act and EPA has defined the 5 components required for delegation to be individual permits, general permits, federal facilities, pretreatment, and biosolids. And federal facilities includes both individual permits and general permits.
I understand that federal facilities may be permitted, but I guess my question is, since the functions are the same as the industrial function activities we've just discussed, would they be similarly treated in permitting development?
In terms of permitting development, yes, they are treated the same. The federal facilities can fall under the general permits, whether it be the multi-sector general permit for industrial stormwater, whether it be the MS4 for municipal stormwater, whether it be construction general permit. They are treated the same, but EPA requires that federal facilities be their own specific program element. Why? I would say you have to ask the EPA.
And do you know what regulation that comes under by any chance? Or is it part of the MOU plan you have to submit to EPA?
It is EPA's requirements for an application for delegation.
I'm wondering, from the prior discussion of the economies of scale, and the state opted to move forward with 402 primacy as well as state surface water, and the state is moving forward with a 404 program, why hasn't the state opted to also move forward with primacy under 404 of the Clean Water Act?
I did not testify to the 404 program. My testimony was all about the Section 402 NPDES program.
I do understand that. I'm just wondering if there have been discussions about, again, since you're operating this program and you will be helping to run the state dredge and fill program, was there discussions about should we take 404 or should we not?
That was not included in my testimony. I cannot speak to that.
When you were answering some of Mr. Stroop's questions with regard to the reasonable potential analysis, do you recall having that conversation? It was just before lunch.
With Mr. Stomp?
Yes.
Yes.
And I think during that testimony, we reached a point where it was understood there would be both operational and costs resulting from the reasonable potential analysis that would be performed. Do you recall that?
Yes.
And at this time, there is no tool to help understand the breadth of those substantive impacts, is there?
So reasonable potential analysis is currently included in EPA's New Mexico implementation plan. Reasonable potential analysis is performed by EPA on every individual permit. So the costs that facilities currently have are a result of reasonable potential analysis. Reasonable potential analysis is how water quality-based effluent limits are developed.
And will the state be implementing the very same type of analysis?
Yes, that type of analysis is called out in 40 CFR 122.44. It is a requirement.
Were both of you in the room when Mr. Armstrong testified? Both panel members?
Yes.
I just have a quick question about that testimony. Mr. Armstrong was asked some questions, and he testified that the department would follow pre-SACIT interpretations and applications, and specifically said they would apply the nexus test to determine whether a permit is needed. Can you tell me how and where that fits in with the program you guys have been testifying about?
So neither of us testified to the nexus. Ms. Lemon did follow up with that. Neither of us have that in our testimony.
Okay, during Mr. Armstrong's testimony, I believe I was asking those questions, and he indicated Mr. Faoud would know how the significant nexus test would be implemented in the context of the state-operated program.
I do not know that answer. I described in my testimony, I testify on the application process, how once it's the determination request is to the department, the language that we are proposing, and then how the department processes an administratively complete application. That's all in my testimony.
So your testimony doesn't include then any discussion or implementation of the significant nexus test as part of the application and discharge determination process?
No.
So if a permittee currently has an EPA permit and 3 years in has to submit another one, would you consider that a new permit or a renewed permit?
So is your question for if they submit the permit solely because their permit is going to be expiring, then it's a renewal permit. If they submit an application to modify their permit, then it will be not a new permit, not a renewal permit, it will be an application for modification.
So let me clarify. So let's say you have an EPA permit right now. It's going to expire in 2 years. So in 18 months, you would submit some type of a permit application to the state if the state takes over primacy. Would that be a new permit, or would the state consider it a permit renewal?
As far as I understand, the state will consider it as a permit renewal.
Is there any appreciable difference in a new permit application versus a permit renewal application? Is it less burdensome, or what the differences are, for example?
I cannot testify to the burdens, but I will testify to the differences. As you asked, if there is a new permit that doesn't include a stricter timeline as a renewal permit does, a permittee is required to submit an administratively complete application for a renewal 180 days before the permit expires. If they do, and the department does not issue or cannot issue the permit within that timeline, then the previous permit continues to be in existence and in effect as an administratively continued permit. So that's the one difference that I can think of.
So if an entity currently has an EPA NIPIS permit, they apply 6 months before that expires to the state, you would continue the EPA permit until the state is able to issue the new permit, even if it takes the state a year and a half?
That is my understanding.
So I was going through your testimony, and I was trying to follow the time frames. And unfortunately, I wasn't successful in doing that. On page 5 of your direct testimony, I believe, you start with kind of permit process for individual and general service water discharge permits. And it seems to start at the application phase. Doesn't it actually start at the notice of intent stage?
Please give me 1 second.
Of course.
So as I tried to explain earlier that my direct written testimony was based on our submitted amended petition in March. As Bureau Chief Lemon testified or discussed that we are proposing new language to incorporate this concern that how would permittees or potential permittees know that they need a permit. That's where we're proposing an extra step or a pre-application step, if you would, in which potential permittees would request the department to make a determination on if they need a permit. So that's why I think that's what we're referring to. We do not call it a notice of intent for individual permits. And for general permits, there is no application process involved. For general permits, to get coverage or get authorization under that general permits coverage is called a notice of intent.
Okay, so the NOI only applies to the general permits.
Yes.
And then you have this preliminary, tell us if we need a permit process for individual permits. And that's not drafted yet, correct?
No.
Okay. So let me ask you this. And I'm sorry if it's repetitive, but I'm trying to match these timeframes so I could advise people. Starting day one, I want an individual permit. Can you tell me what I start with and the timeframes for each next step, as well as if there's any spot there's a delay or pause?
First, so if you do want a permit, if you do not want a determination if you need a permit, you actually decided you want a permit, you apply to the department in the format that the department specifies and with all the information that entails. And the department has 30 days to determine if the application is administratively complete. If the department determines that it is not administratively complete, the department will write back requesting more information with another timeline for the department to provide, for the permittee to provide that information to the department. While that timeline is in effect, the actual permit processing timeline will pause. If the permittee provides the information within a day, then the actual timeline resumes. And again, it doesn't restart, it resumes. So within 30 days from when you submitted the application to the department has to make the administrative completeness determination, with which it will provide you the applicable fees. That's what we're proposing. It's not in the current submitted rules. And then after a permittee pays the applicable fees, the department then has 90 days to draft a permit or draft a draft permit, which has to then go to public notice, and the department has to give 30 days for the public to comment on it. And the public can request a public hearing. If the secretary decides that a public hearing will be held, then there will be a pause until that gets resolved. Once the department has a report from the hearing officer on the public hearing, the department will provide or issue a final draft permit to the secretary, which the secretary will have 30 days to act on or take the final action on. So that's how the 180 days are incorporated in few steps.
So the estimate is 180 days. Is that accurate?
Yes.
The overall process. But your timeline doesn't take into account how long it might take to schedule a commission hearing, have a commission hearing, get the final report from a hearing officer, does it?
No, that's what I said, that if a public hearing is held, then there will be a pause, and that is not feasible to incorporate in a rule how long it will take to play out a public hearing process.
So is it fair to say the bare minimum is 180 days?
Yes.
And it can go up for a year or two beyond that?
It depends on the hearing, which the department has no control over.
Madam Hearing Officer, I just want to call attention. We forgot when Dr. Fawad was testifying to put up his demonstrative. And so to the extent anyone finds it helpful, it does lay out all of those timelines in a flow chart in a sequence.
Thank you. I'm also just trying to identify the stop gaps. So the application has to include the fees, but we don't know how to, well, I think it says in the direct testimony.
So that will change a little bit as Bureau Chief Lemon's discussion that in the draft rules or our amended petition exhibit 28 and 29, that my direct testimony is based on those two. In that, the application fee is included with the application. Now we're discussing to propose language where the application fee will be due after administratively complete determination.
And that's for both the, I'm going to just call it the 0.5 and 0.2 programs?
Yes.
Okay. The administrative completeness determination, you could pause it for a week or 3 months, right?
So we could not, we could request information, and if the permittee provides us the information within 0 days, then there will be no pause, or they could take 30 days or however many days they want. Then that will not be out of the department's control.
So in your testimony at page 7, you say within 90 days of the department's notice to the applicant of administrative completeness, there would be another opportunity for the department to request additional information. And I'm puzzled by that, because if there was information missing, why would you have issued an administratively complete determination? Wouldn't that have been requested at that earlier stage on your testimony at page 6?
So as the term is administratively complete, that will be all the administrative information the department will need. The department might need further information depending on other circumstances. The department may also conduct inspection at the site after the administrative complete determination. So in that case, the department might require more information, as far as I understand.
So 2 different times the department can say, still don't have enough information, and pause the process again.
So I don't recall specifying that there will be a pause within the 90 days. After the administrative completeness determination.
Well, let me ask you this. If the department says we need more information, how's it drafting a permit without that information? It seems you'd have to pause and wait for the information you've requested. Otherwise, you don't really need the information, right?
If we do not need the information, of course, we will not request that information. But what I'm testifying is I do not recall adding a pause in this, in my direct testimony or written direct.
On page 7, you state the department may request additional information, including a new or revised application from an applicant, transferee, or requester. And such additional information shall be considered part of the application. So it seems like at that stage, you could totally restart the process if the department decides to, or the department can ask for more information. And my question then is, would you still meet the 90 days for a draft permit despite saying I need more information?
So as far as I understand, if the previously provided information does not match, there will be, then the department cannot anticipate that in that administratively complete, in the request for information in the administrative complete portion or step. And in that case, it is, I would say, not in the department's control if the provided information is incorrect. In that case, it will probably be on pause. I am not sure about that situation.
So there's the potential for another pause at that stage. If you would like additional information, I mean, even if the information is correct, you could ask for more, correct?
If we need so,
Yes.
if the permittee did not provide all the information, or if the information that was provided was not accurate.
Well, let's assume the information was completely accurate. All of it was fine. But the department says, hey, we want some more information about your operation. Would you pause drafting the permit until you got that information, or would you keep drafting it to meet that 90-day deadline?
So I think the hypothetical you're presenting, we can't tell you because I would need a permit application in front of me, all the information, and what information we thought we were lacking.
Okay, but it's fair to say it could result in another pause.
It could result in a pause. It could just result in a confirmation of, hey, is your outfall really there? Hey, can you confirm your methods on this effluent table? Not all requests for further information are large data projects. Sometimes they're just confirmatory items.
So it may or may not, depending on what the department thinks it would also like to see. Is that accurate?
Correct.
And we just don't know what that timing or how long that pause could be. And we don't know how long it would take to schedule another hearing and do all that other procedural stuff.
We don't have to have a hearing for every permit issuance. That's just if the permit is challenged.
Understood. Let me ask
Ms. Richards, you have 5 minutes.
Thank you. I'm going to wrap up. Mr. Fuad, I think you testified, because I wrote this down, that the denial of an MSGP would not provide an appeal right. You'd have to go through the individual permit application before you could appeal. Does that accurately reflect your prior testimony?
So you mean the denial of coverage for an
Under an MSGP, yes.
I will have to, do you remember where?
It was when you were being questioned before lunch, so it wouldn't be written anywhere.
Then it would be difficult for me to answer, but let me think, if you don't mind. So if the secretary withdraws the coverage or denies when an NOI is submitted?
Well,
Just trying-
all I have written down here is that you actually said, and I quote, denial of MSGP would not provide an appeal. And I was puzzled by that. You don't recall that, making that statement?
No.
Okay. All right, that's all the questions I have. Thank you.
Thank you, Ms. Richards. Ms. Dolan?
Thank you, Madam Hearing Officer and Commission and Chair. My name is Maureen Dolan. I represent Triad National Security, the management and operating contractor for LANL. I have not too many questions for you. I'm going to start with a couple of questions, I believe, for you, Dr. Fuad. Concerning a couple of things that Ms. Richards just touched on. So first, I wanted to ask about 20.6.2.2304 D1. This is the renewal section. I just wanted to confirm that that the department would follow the provisions of 20.6.2.2308 concerning the department's own timeline for processing that renewal application and determination of completeness. I ask specifically because I think that under 2304D, there is not a granular description of the department's own constraints for determining completeness. I might be wrong.
So if I understand correctly, you are asking if in 2304D, it says 180 days, but will that 180 days be broken down as I testified for 2308?
Yes.
Yes.
Okay, thank you. So just to be clear, there wouldn't be a risk of a current permittee running up against a situation where they would have a determination of completeness very, very close to the expiration of their permit.
That depends on if they submit administratively complete application 180 days before.
Okay.
In practice, EPA is seeing people submit complete applications right now the day they are due.
Okay. Okay, thank you for that. This question concerns 20.6.2.2306. I believe this is also for you, Dr. Fuad. So this is in part G discussing terminations, especially in subparts F through H. Is there a standard for what types or severities of non-compliance might trigger termination of a permit?
Not that I know of. It states in the rule violation of a condition of the general permit. So the secretary may terminate permit for that.
Okay. I'm going to ask a similar question in subpart or in 20.6.5, but I'll pause that for a moment. In 20.6.2.2307, this is subparts D and E. These concern permittee notifications to the department. And I'm wondering about timing here. Functionally, does the permittee notification trigger any follow-up obligations on behalf of the permittee, or must the permittee await some kind of determination from the department first? Specifically concerning the necessity to supply a modification request. For example.
Are you asking these apply for both individual and general permits?
It's a granular sort of question. I'm just wondering whether the permittee notifies the department and then proceeds, or waits for the department to respond and request a modification.
So per my understanding, the permittee can expect a response from the department.
Okay.
Instructing or identifying if they need to wait for further information or they can proceed, which I cannot specify right now how the response will be.
Okay, so that's not set out specifically in the rules yet, or it may not be.
As far as I understand.
Okay, thank you. I'm going to move on to 20.6.5 now. This is also concerning terminations. So this is parts D and E. So if actually, I'm going to start with the permit modifications section. Again, I believe this is for you, Dr. Fuad. In part 1, in D1, it states if cause exists, the secretary may modify or revoke and reissue. So just mirroring that, I'm noticing that there isn't similar language in part E. For example, there's no if cause exists, but rather, for example, the secretary may terminate or deny renewal upon receipt of a written request from any person. So I'm wondering what thresholds or standards exist for the secretary to take such action upon request from any person.
So I think I understand your question, that in the previous subsection, it states if cause exists.
Mm-hmm.
And in this one, it doesn't say if cause exists, it just says the secretary may.
That's
and
right.
The specific one you're talking about is B, from written request from any person. What's the bounds of the secretary's decision? I don't think, or as far as I understand, that is not specified in the rules. However, in 6, it says for a written request from any person under that B1, if the secretary decides that the request is not justified, then the secretary will notify the person, and that will not be subject to public notice, comment, or hearing.
So it's just at the complete discretion of the secretary.
Yeah, that decision is in the secretary's purview.
Would the department consider any kind of constraining modification to that section, to either say something like if a pattern of non-compliance exists, or if cause exists, then?
I would defer that to Ms. Lucas-Kamal.
Sorry, my brain skipped. Can you repeat the question?
I'm just wondering if the department might consider any limiting language there. For example, like in section D above that says if cause exists, or further down where E discusses violations, if there's a pattern of non-compliance.
I think we're open to any suggestions to language changes from the various parties.
Okay, thank you. I apologize in advance. I'm going to cover a little bit of territory that Ms. Richards covered, but I'm going to ask slightly different questions. And so I'm going to open this either to you, Ms. Lucas-Kamat, or to you, Dr. Fouad. I just want to make sure that we understand the exemptions language correctly in 20.6.2.2303 in A4 and B6. So after hearing, first of all, I gather from your previous testimony that you were both present for testimony by Ms. Lemon and Mr. Armstrong. Is that correct?
Yes.
Yes.
Okay. I just want to make sure that, again, that we understand how that exemption works. Is any current federal surface water discharge permit holder to understand the exemption will continue to apply when the permit must be renewed?
Oh, can you give me the citation in 20.6.2 again?
2303 A4.
A4.
Yes.
Okay.
So Ms. Richards asked a similar question.
Yes, that exemption is correct.
So that exemption would continue to apply when the permit is up for renewal? That is to say, I'll ask a slightly different question. I may have misunderstood Mr. Armstrong's testimony, but I believe he suggested that a current federal permit holder who discharges into a non-perennial water may need to obtain a 20.6.2 permit rather than a permit under 20.6.5.
Correct.
So that exemption does not hold necessarily true upon renewal if the permittee is discharging into a non-perennial stream.
Correct. There's no grandfathering or exemption from all permitting. This exemption is if you have an existing permit, you don't have to get that same permit again, if that makes. Give me a second.
Another way, forgive me for interrupting your train of thought, but another way of thinking about this might be whether the exemption would continue to apply regardless of whether the receiving water is a WOTUS. As that definition evolves.
So if you have a current Clean Water Act federal permit and a 401 certification, you do not have to get a permit under 20.6.2. If the 20.6.5, so the federal permit or the NMPDS permit goes away, you're no longer exempt from 20.6.5. Does that make sense?
How would a permittee know that it had gone away? I recognize that that is the case for some permittees who are actively seeking to no longer be regulated under the Clean Water Act. But if that's not the case and the permittee is simply seeking a renewal,
They would, assuming we have an NPDS delegation for the NMPDS, when you apply, if it's no longer a WOTUS, we would tell you this now needs to be permitted under 20.6.5. There would be some communication either from EPA or NMED that it no longer qualifies under the NMPDS program.
okay, thank you. This is going to be a strange sounding question at first, but where the proposed rule, so again in subpart A4, states that there is an exemption where a state or federally issued permit is in place unless there is a hazard to public health or the environment that may result. Could that may circumstance ever include discharges that are in compliance with the current permit conditions?
So if I understand your question correctly, you're referring to that permittee has a current federal permit and it's still valid, and could there be a situation that under our proposed rule, this will be a, whatever the phrase is, hazard to public
Yes.
health or the environment? So as far as I understand, the hazard to public health or the environment, the way it will be determined is however the permit conditions are determined, and we have testified, we meaning not me, but the department has testified that our goal is to be consistent with the federal regulations, so the permittees have some certainty if they have to switch between permits, federally regulated or, delegated to us, but still under the federal law or our Water Quality Act. So I personally do not see that situation from arising, but I cannot speak to that hypothetical without specifics.
Okay, thank you. And just a few more questions, again, that overlap a little bit with Ms. Richards' questions. So again, I'm going to, Ms. Lucas Kamat, refer you to your direct testimony in Exhibit 5 on page 12. I believe correct me if I'm mistaken, but I understood your testimony to be saying that that the federal facilities program is an element that EPA has required. It is one of the elements that EPA requires it to be described in New Mexico's application for delegation.
Correct.
Could you provide just a little bit of additional information about where that requirement resides?
I am familiar with it in discussions from EPA that is what's required in the memo of agreement. I know it from their web pages and their chart of which states have delegation under which elements. I do not know off the top of my head where that specifically comes from.
Okay, so just to be clear, it's not cited to in an exhibit, for example.
It probably is in one of the exhibits since we included both the Clean Water Act and 40 CFR. I just do not know off the top of my head what section it is.
Would it be possible for either you or another witness or counsel to provide a little bit of additional information about that? I don't know where the citation for that program exists.
And this is for federal facilities.
Yes.
A place to start looking is 40 CFR 123.25. If it's not there, I can help point to the next batch of lists of places that it could be.
So forgive me, this might not be a question for our witnesses, but you believe it is a regulatory requirement
To have a federal facility component?
Mm-hmm.
Yes, and if it's not listed in federal regs, I hate to say there are a host of other places, but there are a lot of things that make up the total list of what all goes into the requirements to have what components are required and yeah.
Madam Court Officer, I would object.
Hold on.
Yeah,
so we have an objection from Ms. Richards. Ms. Dolan actually was asking counsel for an answer on a legal citation, if you will. So are we done with that topic now, Ms. Dolan?
Almost. The memorandum of agreement, is that just exhibit 76? Is there another one? Because I don't know what other memorandum of agreement is in your exhibits.
No, we don't have the memorandum of agreement yet.
Okay.
We have to have rules first before we can proceed to that next fun step.
Okay, I can leave that to Ms. Lucas Kamat to answer these next couple of questions. So again, does any NMAD exhibit, do any of your exhibits, Ms. Kamat or Dr. Fuad, supply information about EPA's communications with NMAD concerning primacy?
No, mine
Might
do
not be for your testimony. Okay.
Mine does not either.
And just a couple of additional questions. The federal facilities program, as you outline it in your direct testimony, Ms. Lucas Kamat, by program, are you referring to anything more than the implementation phase? What else is involved in the program?
So the federal facility program would require like in our memo of agreement for delegation, it would describe what actions we're going to take. So it would just be part of our application. And so for federal facilities, it would include general permits and individual permits under the NPDES program.
So this is something you still need to outline and supply in the application.
Right. We need to have the rules first before we do the application. So yes, we still need to write it out.
Okay. And then I think I know the answer to this question, but is the federal facilities program outlined anywhere in the proposed rules?
No, because federal facilities would either be individual or general permits, so it is not specifically called out.
Okay, that concludes my questions. Thank you very much. Thank you, Ms. Lucas-Kamat and Dr. Fouad. I appreciate your patience. Thank you.
Thank you, Ms. Dolan. Do we have Mr. Maxwell or Mr. Weatherby? No. Nope. All right. Mr. Kermsey?
Thank you, Madam Hearing Examiner, Mr. Chair, and the Commission. Thank you, panel. I have a few questions. I think we'll start with Ms. Lucas-Kamat. You testified at the top of page 16 that the department proposes to notify any downstream nations, tribes, and pueblos of any permittee modifications that will affect the quality and quantity of discharges, correct?
Correct.
Is there a geographic limiting principle proposed that defines how far downstream the notification obligation extends?
No, that is something we will need to discuss with the individual nations, tribes, and pueblos.
Okay, and what happens if there's a disagreement?
We continue coordinated in consultation to address the disagreement.
And how does that affect the permittee? Would the permit be delayed?
Not necessarily. The main way the consultation with downstreams, Indian Nation, tribes, and pueblos affects a permittee is that affects what water quality standards may need to be considered for your permit. And so that's really dependent on the nation, tribe, and pueblos. Sometimes the nation, tribes, and pueblos have the same water quality standards as the state. Sometimes they do not. And it's very individual.
Okay, so I guess I'm getting back to this disagreement. So if you say it discharges to an ephemeral stream and then NMED says it goes up to here and the ephemeral stream is dried out, it doesn't connect to anything else. But the tribe says, or the pueblo says that it does connect, and now we want to apply our standards to this permit. Is there a way to resolve this?
I know that the State Tribal Collaboration Act has some things outlined. So yes, there is a way to resolve it. At this point, I can't speak further to a hypothetical.
Yeah, I was just wanted to bring up that situation just to add some hopeful clarity in the final proposed rule. And if we could move on, when I was questioning Ms. Lemon, she indicated in her testimony that Ms. Lucas-Kamat, you would be the appropriate witness to ask about certain permit modification requirements. Do you recall that conversation I had with her?
I think so.
Okay. So then, do you agree there would be situations where permittees' voluntary improvements mid-permit of its treatment methods would require a full permit modification?
Hypothetically, yes.
And how about if it's discovered through the monitoring requirements that the permittee's treatment is performing better than anticipated during the permit term? Does that require a full modification application?
It would, so anytime a permittee changes something in their plant, we have a requirement that you notify us of the changes. It could be as simple as adding a new lift station. You could bring online a whole new plant. You could change a valve. You could change the chemical you use in part of your nutrient optimization. When you notify us, we would ask for details to determine if a modification was required.
Okay, so if the treatment system didn't change, we just discovered that, or the permittee discovered that it was performing much better than expected, that wouldn't necessarily require an automatic modification.
Correct.
And under these scenarios, let's say the second one was a little more ambiguous. So let's say with the voluntary modification, is it true that under 20.6.22314D2, if they didn't notify the department, the secretary could terminate their permit?
Could you give me the citation again, 2314?
Yes, D2.
So in D, it states if it indicates that the standards for in 20.6.4 are being violated. And so I think if you have a permit and you are meeting water quality standards, I don't think we would terminate the permit because you're not exceeding 20.6.4. We would ask you to please notify us of changes.
Okay, so it's just a matter of letting you know we're improving the treatment, not necessarily everything needs to be submitted again.
Correct.
As far as the new application.
You know, as an example, we've had people put on new lift stations. They've optimized their nutrient systems. They've changed chemicals. They've moved a valve. They send us an email. We look at it. Save the email for your next inspection.
You're right. And this is a different topic, maybe a little bit more broad, but if a permittee were to discharge to an ephemeral stream, do I need both a surface water and a groundwater permit?
You would need a surface water permit. There is a clause in the groundwater permits that if you have an NPDES permit, you don't necessarily need to have a groundwater permit, but there's also a clause in the groundwater rules that can require discharges to intermittent. And so that would, the goal is not for us to doubly regulate.
Because I see, I think it's 3106, ephemeral streams aren't excluded from groundwaters, and that hasn't been amended in any of the exhibits. And then I see now the new definition is extending to, or it's proposed to all ephemeral streams. I guess that wasn't a question, but Madam Mayor, that ends my questioning. Thank you all. Thank you, panel.
Thank you, Mr. Kermsey. Do we have Ms. Miller on the platform? No. Mr. Mickeljohn, do you have questions? Yeah.
Good afternoon.
Good afternoon.
Conservation voters, Mexico. Great, thank you. In your rebuttal testimony, Ms. Lucas, come on page 3, you said that as to certain things that I had asserted and that Rachel Kahn had asserted, that would be burdensome and is not required by federal regulations or state statutes. Do you recall that?
I do.
It's also the case, isn't it, that what I asserted and what Ms. Khan asserted is not prohibited by federal regulations or state statutes. Isn't that right?
You're saying is not prohibited?
I said, isn't it the case that it's not prohibited by those?
Correct. It is not prohibited.
Okay, thank you. And one of the things that you said about, I think it was about my proposals, was that it is burdensome and resource intensive. I assume you're talking about being burdensome for the department. Is that right?
That is correct.
So if what I suggested was undertaken by somebody else, that is by the applicant for a permit, for example, that would not be burdensome for the department, would it?
No, it would not.
One of the things that I asserted was that if a notice is published in the newspaper, it ought to be published in a display ad that is not in the classifieds or legal advertisements. I assert that for section 20.6.2.2311A3. Do you recall that?
I do.
Do you read the daily newspaper?
Actually, I do.
Do you read the legal ads in the daily newspaper?
I'm a news nerd. I actually do.
Can you tell me what school district had several ads in the daily newspaper? Which, I beg your pardon, what daily newspaper do you read?
I read the Albuquerque Journal, the Santa Fe New Mexican Online, and occasionally the Carlsbad Current Argus.
Can you tell me, please, what school district had several ads in today's Albuquerque Journal legal advertisement section?
I was not home because I needed to prepare for this testimony, so I did not read it this morning.
All right. Do you generally read the classified ads in the newspaper?
I skim them.
Do you read them every day?
I actually do.
Pardon me?
I actually do. I like the newspaper. I don't read them on the day they're published, but there's a stack. I get to them.
You are unusual if you read them every day. Mr. Proud, I have the same questions for you. Do you read a daily newspaper?
No, I do not.
Okay, that answers that line of questioning. Thank you very much.
Thank you. Ms. Fox, do you have questions? Ms. Fox declined. Ms. Udall, I think I saw you on the platform. Do you have questions?
Thank you. I don't have any questions.
Thank you. And Ms. That's it, right? Do you have redirect?
We have a little bit of redirect.
All right.
Ms. Lucas Kamat. Regarding SB 21, did the legislature require the commission to promulgate the regulations for these two programs, or did they leave it as optional?
No, they said that both regulations, well, they said both programs needed to be promulgated.
Did the legislature articulate that the rules could be promulgated whenever the commission wanted, like in a few years or 10 years?
They said,
Madam Hearing Officer, these have been asked.
I need you on a microphone, sorry.
These questions have been asked and answered, and these are not redirect questions. They're the same questions yet again. I would object to repeating just for further clarification.
All right, so I think this is proper redirect. You allowed a lot of the same ground Mr. Boutier did, and this is a friendly questioning around the same topic. Go ahead, Ms. Weatherly.
Just to clarify, but I believe the question asked earlier is if the commission needed to promulgate these regulations urgently or at this time. So I'm asking if the legislature articulated in SB 21 anytime, either urgently or later, that the commission had to promulgate the regulations.
well, first off, there originally were two Senate bills, and they combined them together. They took Senate Bill 21 and Senate Bill 22 and combined it into 21, which meant they wanted them to be considered together. And the Senate Bill 21 says shall.
And so just to clarify, did the legislature articulate that the state program rules should be promulgated after the NIPD's program rules?
No.
Thank you. You were asked if you had received any complaints from NIPD's permittees about the way that EPA administers that program. Are you aware of any complaints that permittees made to EPA about how they administer that program?
I am not aware of any.
Thank you. Can you please elaborate on the benefit of having the two programs in place if, let's just say, when the definition of WQCC changes?
Can you repeat the question, please?
Sure. Can you please elaborate on the benefit of having the two programs in place when the definition of WQCC changes?
One of the benefits of having both the state permitting program and the NMPDS program is that as WQCC changes, if we have one comprehensive, holistic permitting program, the permitted regulated community doesn't have this whiplash of, do I have a permit? Do I not have a permit? Oh, I'm moving out of a permit. Now I'm moving back into a permit. And so it can easily flow from one permit program to the other.
Thank you. Regarding exhibits 79A and B and the definitions in those exhibits, are those definitions different from the now stricken second amended petition that was filed?
No, they are not.
Thank you. Is reasonable potential defined in the Federal Clean Water Act?
It is not defined in the Federal Clean Water Act. It is referred to in 40 CFR 122.24.
Thank you. One more question. Do the rules for the NIPD's program, 20.6.5 NMAC, Do they need to be in place before the department can apply to EPA for primacy?
Yes.
Thank you.
Okay, I have a few questions for Dr. Fawad. First, can you please speak to the clarification that NMED Exhibit 79B provides in regard to the Notice of Intent Review and Authorization of General Permit Coverage?
Earlier, I was not able to locate the 30 days of extra time provided for the department to assess and make a determination with respect to general permit coverage in 20.6.2 NMAC. I'd like to clarify that such a provision exists in the department's First Amendment petition submitted in March 2026. This section is in 20.6.2, 2306.c3 NMAC. However, in that submission, 20.6.5 NMAC did not contain comparable language. I wanted to clarify that in order to be consistent between 20.6.2 and 20.6.5, department proposed language with the same timeline in its Exhibit 79B in section 20.6.5 303.a.4.b.
And after further review of the proposed rules, can you provide some clarification as to where the factors are that would be considered for a permit term greater than 5 years?
Yes, those factors are listed in 20.6.2, 2314.h. It states there shall be a demonstration for permits that have longer terms than 5 years. The demonstration shall include justification, which may include facilities with good compliance history, less complex and minor facilities, facilities with state-of-the-art treatment technologies, or similar reasons.
Those are all my questions. Thanks.
Thank you very much. I'll start at this end this time for commission questions of the panel. Commissioner Vihel? No questions. Commissioner Sloan? No questions. Commissioner Bayless? Terrific.
This is about fees. I'm looking at the City of Santa Fe NPDES permit. I see that there's about 8.5 million gallons a day permitted when you calculate it out. There's 76,000 people cited in the permit language that produce that 8.5 million. That's 112 gallons a person, which is obscene. Fortunately, the city government thinks so as well, because I understand they've had a water reduction program in place, and they've done all kinds of, I suspect they've done INI stuff. They've done water low flow fixtures. They've encouraged water conservation, which should be on the top of our list of things to do. By doing that, they've actually produce not 112 gallons a day as they're permitted, but they produce 66 gallons per capita per day. This is pretty good. I'm wondering if the fee system could be altered to where this kind of program of water management, water savings is rewarded. And in other words, it would be as simple as when you calculate the fees, you not do the MGD that's permitted, but you do the MGD that's actually in use after these conservation measures. So has the department given consideration to this approach?
So Ms. Linden and Mr. Connolly discussed fees. Fees are outside my testimony. So Mr. Connolly and Ms. Lemon gave the testimony on the fees and discussed how the fees were calculated. That is outside of my testimony.
Madam Hearing Officer, I'll also add that we do plan to call Shelley Lemon again to discuss fees. So you'll have another shot at answering or asking that question.
I've had reason to listen in, which I've done. And make eye contact with people who are able to influence that kind of thinking. And but I will thank you very much. I'll try to remember to ask that question.
Commissioner Thompson?
Thank you. Thank you. I have a bunch of questions. Some are almost trivial. So my first question, it's a terminology question. We've got NPDES program, and I understand that very well. And then NMPDES program, that is the program that the state is applying for under 20.6.5 to take primacy of the NPDES program. Is that correct?
That is correct.
Okay, and then we have a permit program that I don't recall hearing a nice, succinct name for it. And that would be a state program to deal with discharges under surface waters of the state that are not waters of the U.S. Is that correct?
That is correct.
Does that have a name that I can refer to?
Not a good one.
Okay, well, I'm going to call it, for purposes of my questions, the state program.
That would work.
And if you have any questions, if I'm asking things that are confusing, please ask for clarification. My next question is on a couple of definitions. So you refer to biosolids, and I believe that is in the NPDES program. Is that correct?
Let me double check. Let me do this.
I'm hearing crickets. So.
It actually was a definition for sludge in 20.6.27.
And that's your complete answer?
Let me ask what the question was again.
The question is, I believe that biosolids is a terminology used in the federal NPDES program, but biosolids is not defined in the two regulations that are proposed before us today.
That would be correct.
And there's another, and that So this is probably, where are let me step back. Where are where is sewage sludge? No. Where is sludge defined?
Sludge
In state use.
it is from the Water Quality Act, section 74-6-2.
Yeah, that's where I found it as well. And you've heard me express concern about definitions in the Water Quality Act before, and this is one that I don't like. Another one I don't like is domestic wastewater, because I believe domestic wastewater refers to some very large municipal treatment systems, such as the Albuquerque-Bernalillo County Water Utility Authority. Is that correct? Does the water authority treat domestic wastewater under the usage according to the Water Quality Act?
I'm seeing the definition for domestic liquid waste. Let me look up the Water Quality Act real quick.
This is the minor point. I would strongly encourage the NMED to amend the Water Quality Act at its first opportunity to change domestic wastewater to municipal wastewater, because it's a lot. Municipal wastewater in most POTWs is much more than just domestic. And that's just an editorial comment. I've made it before. And that's enough of that. When do you expect the definition of waters of the U.S. to be finalized?
That is currently with EPA and the U.S. Army Corps. I have no idea when they intend to publish the most recent version of the rule.
Have they released a preliminary definition?
They accepted public comments on the most recent definition. I do not recall off the top of my head when that public comment period closed.
But they have released a preliminary.
Yes. Well, they released in the Federal Register a draft version of the rule and accepted public comments.
Yes. Thank you. That's my understanding as well. So based on that preliminary definition, do you have any estimate of the numbers of existing individual permits that will no longer be subject to EPA jurisdiction?
I do not.
Could you develop an estimate? How much effort would that take?
That would be a request of EPA because they're the only ones that can make a jurisdictional determination if it's a WOTUS or not.
I understand it's a jurisdictional question, but it seems to me when you're developing plans for a new program, the NMPDES program, it would be pretty important to know how many permits you're going to have to administer. And so you could look at, again, it seems to me reasonable that you could look at the proposed definition and come up with an estimate of the number of permits that will have to be issued by the NMED.
The latest communication with EPA, which was late last week, was 95 individual MPDS permits.
But that's the existing number, yes?
That is the only communication I have to base it on.
But you're a permit expert. Can't you look at the definition, the proposed definition, and come up with some kind of a ballpark estimate of the number that will no longer be subject to the federal jurisdiction?
In my experience, the permits that we've lost so far due to changes all had to do with closed basins. And so the 95 individual permits reflects the elimination from closed basins. Most of our permits are on the main stems of the Pecos, the Rio Grande, and the San Juan Basin.
Okay, thank you. Ms. Lemon testified the other day, or mentioned the other day, that Silver City would likely no longer be under jurisdiction of EPA. Is that?
Silver City is no longer under the jurisdiction of the EPA because it is in a closed basin.
Can you give me any other examples?
Baird, Cloudcroft. There's a mobile home park in Silver City that had an MPDS permit and a groundwater discharge permit that's no longer required to have the MPDS permit because they're in a closed basin.
Thank you. Okay, turning it around. So those communities you just mentioned would now be subject to the state permit system.
Correct.
Okay, and presumably there are other communities in closed basins that also would be subject to this the new state permit.
Theoretically, yes.
Any idea how many?
That was similar to a question. I know it was included in Mr. Connolly's fees. I don't know. I don't have that in my testimony. I don't have it off.
I know it's not in your testimony, but it seems to me, and I apologize for interrupting. Have you finished?
I don't remember now, so go ahead.
Okay. It seems to me reasonable to expect you and your program to at least come up with an estimate of how many new permits would have to be issued under the state program in order to plan the number of staffing positions and the cost estimates and such.
And as I said, that information went into Mr. Connolly's calculations. I don't know it off the top of my head. For individual permits, it's a handful. It's not a large number. It's mostly closed basins, so we already know like the Tularosa Basin, the Estancia Basin, the Mimbres Basin, like we know those basins. And then also there's a couple of facilities we know discharge to Playa Lakes, but I don't have that number off the top of my head, and I don't want to testify to a swag that I just pulled out of thin air.
Okay, I understand that. And I should have asked this of Mr. Conley. It looked to me like his estimates were done using an EPA NPDES permit tool. Is that correct?
I cannot provide information on Mr. Conley's testimony. He has it in his testimony. I don't know the answer to that.
Did Mr. Conley submit a final report for the contract work that he did to NMED?
The contract work is ongoing and it's separate deliverables, so I do not have a final contract report at this time.
I almost said Chair Thompson.
Yes.
Vice Chair Thompson. So we filed today 2 of the exhibits that some people, commissioners and parties were asking for as NMED Exhibit 80 and 81.
Yes.
that were part of Dan Connolly's modeling.
Yes, I saw those, and they were informative. Thank you. So who do I ask questions about those exhibits? If Mr. Connolly's not here.
Shelley, we'll call Shelley again. It may not be today or tomorrow, but we'll call Shelley again when we get around to it.
Okay. I guess this is probably my last line of questions. Mr. Connolly said that about 19%, about 20%, let's say, of the permits issued by EPA Region 6 have expired. He couldn't give me an exact number, but 20% seemed to be the number that he was kind of circling around. You recall that?
I do.
So it seems to me on day one, when the state assumes responsibility for the federal permit program, the NMPDES program, there's going to be a rather large backlog of permits that need to be addressed right away. Is that correct?
Currently, no, because the EPA Region 6 average is not the New Mexico average. I verified on the EPA backlog webpage, there is one permit in backlog for New Mexico. Now that is based on the end of federal fiscal year 25. So that is an October 1st, 2025 piece of data. It may be two now. And there are terms that get used interchangeably that aren't the same. Like backlog means it's expired. It's not administratively complete. It needs to be addressed. There are administratively complete permits that haven't been reissued for various reasons too. And then there's permits that expire because facilities do not turn in their re-applications, their renewals on time.
And there is, what's the source of that information?
The source of the backlog number, if you Google EPA backlog, EPA has a whole web page dedicated to the different backlogs in the different regions. And they track it by EPA has a backlog, the state has a backlog, but since we don't have a permit program, New Mexico has zero backlog because we don't have a program.
Okay, well, that's really interesting. That is really interesting. And why I think it's especially interesting is EPA with this very small permit staff. I think Mr. Connolly testified that it was 6 or 7 permit writers, has a backlog of only 1 or 2 permits.
So it is EPA Region 6 currently has 7 permit writers. There are 1.5 permit writers at headquarters who work on general permits.
So, my first impression is that that's really efficient compared to Mr. Connolly's projection that we're going to need 57 total. And I recognize that many of those are not permit writers. They're involved in compliance and enforcement and inspections and so forth. But still, that's remarkable. One last question, and then I'll be quiet. How many EPA employees are involved in enforcement in New Mexico? Do you know?
I do not, because enforcement's stormwater is handled by wetlands and the POTWs are handled by a separate group, and it's not an apples to oranges workload. Like I can tell you 4 for stormwater.
So I believe, yeah, right now, it would be 4 for stormwater, but I would add that those stormwater individuals are not dedicated for New Mexico. It's for the entire region. So for enforcement staff, they're not dedicated to New Mexico. They are, we have one coordinator for stormwater, one coordinator for everything else. But everyone else has the responsibility to ensure compliance in the entire Region 6. It's difficult to distinguish how many are.
So yeah, for stormwater, there's 4 people that work on stormwater, 4 people that work on concentrated animal feeding operations, 2 people that work on the whole effluent toxicity permitting, 1 person who works on compliance and enforcement pretreatment, 1 person who works on permitting pretreatment, and then there's 8 or 9 enforcement officers.
And that list that you just gave me, those are all dedicated to New Mexico?
In some form or another, but that also doesn't include legal staff, the person who handles public notices, this, for lack of a better term, male staff, like administrative staff who take in all the applications, the people dedicated to the database. And so the 57 that Mr. Connolly and Ms. Lemon discussed includes IT, HR, legal staff, administrative staff, financial staff, vehicle coordinators. It's not just permit writers, compliance staff, inspectors, and enforcement staff.
I understand. But for example, and this is for, I guess, Dr. Fuad, you see there are 4 stormwater people, and those are 4 stormwater people just working on New Mexico stormwater issues.
No, for the entire region.
Okay. All right. Well, thank you very much. I appreciate it. It's very useful information.
Mr. Chair?
I will try to get to this. I will try to get through this. It looks like my computer has just died, so I'll give up on that. Luckily, I have lots of scribbling notes here over the last few days, and I'm going to try to. I have a lot of little notes here from the last few days. Okay, and so I'll try to just focus on NMPDS program. All right. So regulation 5.103, conflict of interest. Where did that come from?
EPA and the Clean Water Act.
And this is in their rules, or where is it in?
So, Madam Hearing Officer, if I can answer this.
Go ahead.
This language is in 40 CFR 123.25C.
And it's taken verbatim from that?
It's nearly verbatim. EPA provided some comments to us that our language that we previously had was not acceptable. So the language that shows in Exhibit 79B was our effort to clarify 20.6.5.103, which I'll see if you have another question.
Well, my concerns are twofold. One, legal, which is we have a very similar conflict provision in the Water Quality Act.
Correct.
Similar, but not the same.
Correct.
Different percentages, different terms, etc.
And
so that's a bit of a concern how EPA's requirements and our statute lay out there.
EPA commented that the existing conflict of interest in the Water Quality Act would not meet their requirements because it did not require a member of the commission to recuse themselves from all permitting decisions. So there would be two different standards depending on the type of permit.
Okay, well,
and we've also asked for like super specific application questions because this has to do with receiving a portion of income within the last 2 years, separate and apart from whether or not a commission member may be receiving some type of pension or other benefits from a previous employer. But we were asking, like, you know, upon that 2-year time mark, could a commission member then listen to NMIPD's and be a part of NMIPD's permitting matters, actions?
Okay, well, two concerns here. One is the conflict with the statute, and I don't know whether you're going to need to go back and amend the Water Quality Act to comply with the federal rules. And the second is the legislature has, of course, designated one member of the commission to be a representative of county or local governments who are often the permit holders who appear before the commission. So that's a problem.
In B3, 103 B3, permit holders that are, that is state government, department or agency of state government.
Yeah, it's not local, and it's not local or county.
We can check.
That's the issue.
We can check about that. They would have to, at this point, they would have to recuse from all NMIPD's permitting actions that came before the commission.
Okay.
Not the state.
All right, I'll try to move on here then. Section 5-201. Okay, this is your adoption by reference. There's a whole series of parts here. There are boxes full of copies of these CFRs here. I counted in your exhibit list over 3,500 pages of CFR that are listed as exhibits. This is obviously for the NMPDS program, the core of the program. So do we have much testimony explaining what's in these CFRs? Kind of be useful for the commission to know what we're adopting by reference, even if it's just a list and outline of what they are. I mean, I've gone through your all's testimony, and I haven't, other than talking about section 124, which we'll get to, which is the procedural section, I haven't seen a lot of discussion about all these other things. It's like this thing called subchapter N, which is 72 parts of the CFR, 1,500 pages. What is it? What are we adopting by reference here?
Subchapter N is for pretreatment, and it's all the effluent limitation guidelines. So it's all the technology based.
It would be good to know what we're adopting by reference here, because that is the core of the program.
We can create a list.
With that, I mean, the analogous situation, going back through my personal experience, is, say, the Environmental Improvement Board's hazardous waste regulations, where they similarly adopt huge portions of the Code of Federal Regulations. But when they do that, for each part of the Code of Federal Regulations, they go through and have a list of what they're accepting from those regulations. Yeah, and I'm wondering whether the department has done a similar analysis here. Because often the issue is federal regulations will say the regional administrator will do X. Who's that? Well, the hazardous waste regulations say under this section, regional administrator means Secretary of the Environment. Okay, we don't have that in these adoption by reference here. Okay, and so I don't know whether we need to go back through those rules and kind of see whether there's anything that needs to be changed, make it clear. But if if the department is specifically using those regulations, how does a state agency use them?
So a couple of things in terms of definitions and the translation between if there's an instance of like regional administrator, we give a nod to that at the beginning of the definition section. And then we also have a definition for regional administrator that says what it means similarly here. And then again, we can create a list of what each of these are. On the whole, this section 20.6.5.201 aligns with a laundry list that's under 40 CFR 123.25 of required sections that we have to establish with EPA that we have at least the authority to enforce at that federal level, baseline level. We can create a list for you that gives you titles of what everything is.
Okay, well, and that would also be helpful. Why are these required? Do we have to adopt these for a program? I don't know how we're going to do this in the course of an ongoing hearing here, but
yeah. So I'm not sure what the department will be able to provide between now and Thursday. Another possibility, obviously, is for them to address it in their post-hearing submittal in terms of, because it looks a lot like argument, why something would be required.
well, it's simply a reference to the federal regulation that says, 125. The 125, 40 CFR 125 is the provision that says to have an approved state program, you have to have A through Z, okay? And included in that are a number of these regulations, okay? So that's a pretty simple thing to get into the record for this proceeding, so we can justify adopting these by reference.
Yes, Mr. Chair, I'm very sorry to interrupt your line of questioning here, but we do need to stop several minutes early so that we can have a scheduling discussion, because it's clear to me we're not going to be able to excuse this panel by 5. And we had commitments to Ms. Taylor for her traveling witnesses, and Mr. Brooks has a request for his traveling witnesses. And so I want to talk about that.
And you'd like me to stop?
Yeah.
They would like
I'm very sorry. I'm very sorry. I see you have notes. Keep your notes. We'll pick right back up where you are leaving off. But one of the things I think we should talk about at this point, because we're not getting to the end of this panel by the end of this day, with 15 witnesses left to go from this morning, is whether we should start at 8 or 8:30 in the morning, just to buy another hour, half hour. So actually, I think it might be good, Kim, if we go off the record, because I'm not sure it's helpful. Alrighty. And I will, obviously people are still on the platform, they can hear us, but I don't think that this needs to be on the transcript. So let me turn to the commission first. How are you feeling about starting earlier?
Madam Hearing, my only concern is whether there's any argument that this is not properly noticed.
Oh, actually, so Mr. Ugarte, my understanding of these things is that if we announce at the end of one day that we're having a different start time the next day, that's okay. I defer to you.
Madam Hearing Officer, I'm going to look at the notice.
So while he's looking at that, the first commitment was to Ms. Taylor, and then we have your request. Ms. Taylor, what do you have? We need you on a microphone. Do you have some estimate?
Yes, ma'am. I think that our expert Rick Cox will take half an hour, and Senator Steve Lanier probably that amount of time.
Okay, Mr. Brooks, what's your estimate for your witnesses?
I don't know. I think someone
I estimate that for the agricultural witnesses, the MRGCD witnesses, plus the other 3 agricultural districts, we could be done in between 2 and 2.5 hours, including cross. Now that takes into account some assumptions about lack of interest by the other parties. But for directs, certainly we could be quite quick and be done within an hour, I would say.
All right, Mr. Boutsier, if you would find a microphone.
Yes, Madam Hearing Officer, you may not have seen that Serafina Saluja sent around an email that Mr. Chad Gaines only can be available to testify for the Natural Resources Partnership tomorrow. I would estimate his testimony would probably last 30 minutes. It is on fees, so it might draw some questions, but I can't estimate how many cross-examination questions.
Right, okay. And Mr. Micklejohn.
Thank you, Madam Hearing Officer. I will be the only witness for Conservation Voters New Mexico. I expect my direct testimony to take 15 minutes or less. And I don't know how much cross-examination there will be.
Do you have any, are you going to be with us for the duration though?
Yes, I'm flexible.
Okay,
Thank
that's
you.
terrific. And I assume this panel is available for the duration. No, they're not.
They're not. Some of this panel are not available on Thursday.
Okay. So we have tomorrow and Wednesday. All right. What say you, counsel?
My understanding, Madam Hearing Officer, is that that has been the practice with the Water Quality Control Commission. We've been in other settings where, like this, on a day-to-day basis, you realize that you have to adjust the schedule or a time depending on witnesses' travel plans and things like that. So I'm not sure what time was being proposed.
8:30. I'm not married to either one of them.
Yeah,
I'm just throwing it out.
I mean, it's a day, so. I think if we do that, we talk to the parties here, and then Pam and Louise can send out an email, give notice, and then the public comment is at 1. So that would be the unchanged, I would presume, which would be those who would be getting maybe not involved in the notice that goes out today.
Okay. Yes, very definitely. Pam and Louise would send an email to all commissioners and an email to all parties. And can certainly put something on the webpage as well. All right. So any other ideas? No. Mr. Chair, you want to call it?
I'm good. No, Pam and I just looked at the notice that was in the New Mexico Register. It simply states that the first day it's 9 a.m. and then just says it will continue for days afterwards. So there's nothing in there stating that each day will begin at 9 a.m.
We learned that the hard way, Mr. Chair. All right. All right. We'll start in the morning then with Ms. Taylor, and then Mr. Brooks and Mr. Gaines, and go back to this panel with enough time for all commissioner questions no later than Wednesday afternoon. That everybody good? And Ms. Taylor.
I'm just unclear because you said both 8 a.m. and 8:30. Which one?
Yeah, so Edwin want to throw out a suggestion?
I would prefer, if possible, 8:30 because my witness who's flying in today, he expected to be there at 9. Okay. So if you don't mind.
All righty. Mr. Bootsier, 8:30?
I think that's okay. I do drive up from Albuquerque for this proceeding, so I prefer 9. It seems like, based upon the discussion of who would be presented and the fact that we would only have commissioner questions left for this panel, that we're not really, I don't think, too much at risk of not completing this group by Wednesday, by the end of Wednesday.
I agree with you.
But if the pleasure is to start at 8:30, I'll do that. I was planning to meet with my witness at 8 o'clock tomorrow, but I can adjust that to 7:30.
All right. I get nervous, and in my head, we were going to finish this panel today. And the questioning has been complicated. So let's start here at 8:30. And
Officer, we could present this panel for questions at 8 a.m. in the morning.
It doesn't sound like there's a lot of support for 8.
Just to allow everybody else some flexibility. If they were thinking 9 was when they were on.
I see. Let me ask the commissioners, just generally, does any of you have questioning that you think would exceed about 10 minutes? No?
I have a little more.
You have more? No, I understand you have more.
Do you mean for this panel?
Yeah.
I have a few questions. And honestly, I'd rather continue with them. So if 8 o'clock with them would work.
And then Ms. Taylor's witness could appear at 9. Mr. Bootsier's, you could do your breakfast prep or whatever. Okay.
Excuse me, I'm sorry to interrupt, but Sarah Stevenson has her hand raised.
Okay, thank you for pointing that out. Ms. Stevenson.
Yes, thank you, Madam Hearing Officer. I would request of Ms. Taylor if the agricultural districts could follow this NMED panel. That's because I have a medical appointment that I've tried to get changed. I'm not able to. And so we would really like to get the agricultural districts finished before 1 p.m. So if that is amenable for the districts to go first and then Ms. Taylor and her witnesses to follow.
Ms. Taylor.
That's fine with us.
It is. Okay. All right.
Thank
She
you
said
very
it's
much.
fine. Thank you for that. So if we say the rest of commission questions will only be about a half hour, we could start at 8:30 with the department panel, and then ag witnesses would go no earlier than 9, I think.
But
yeah.
Did we get everybody here about what their questions? They have questions.
How many you guys have? I have a few.
But you don't think it's going to go a long time? And I know Commissioner Hall was on the platform. Okay. All right. So let's start at 8:30. Then we'll return to this panel and we'll make it to ag as fast as possible. Thank you all very much.
No, it's not last week. I stayed up here, but